Hello, am I audible? Good morning, everyone. A very warm welcome to each one of you who is present here today. I am Professor Ram Hazari, Head of the Department, Political Science of Vasantrao Naik, Arts, Science and Commerce College, Shahada, District Nandurbar. We all are very excited to have this opportunity to explore and understand the intricacies of intellectual property rights, which are of immense importance in today's rapidly evolving world of innovation. First, I would like to pay my tribute to our source of inspiration, Karmasakshi late Honorable Nana Sahib Premchandji Jadhav, founder president of Satpura Shikshan Prasarak Mandal, Dhule. I express my sincere regards to Honorable Bharat Jyoti Ai Sahib Ashatai Premchandji Jadhav, chairperson, Sonamai Shikshan Prasarak Mandal, Dhule. Honorable Advocate Appa Sahib Sudhirji Jadhav, chairman, Satpura Shikshan Prasarak Mandal, Dhule. Honorable Professor भैया साहेब संजयजी जाधव, सेक्रेटरी, सातपुडा शिक्षण प्रसारक मंडळ, धुळे. Honorable सौ प्रतिमाताई सुधीरजी जाधव, व्हाईस चेअरपर्सन, सोनमाई शिक्षण प्रसारक मंडळ, धुळे. Honorable सौ वर्षाताई संजयजी जाधव, सेक्रेटरी, सोनमाई शिक्षण प्रसारक मंडळ, धुळे. Honorable Professor Dr. हिमांशु भाऊ जाधव, Administrative Head, कर्मसाक्षी प्रेमचंदजी जाधव, Educational Campus, Shahada, District Nandurbar. Also, our principal, Honorable Dr. D.D. Rathod, sir. I once again welcome you all to this National A Conference on Intellectual Property Rights. Intellectual property rights serve as the backbone of innovation, creativity, and economic growth. They safeguard the work and ideas of creators, ensuring they are recognized and rewarded for their contributions. Today, we have with us distinguished experts, speakers who will share their insights on various aspects of IPR. We are honored to have Professor Dr. Bharat Suryavanshi sir, Assistant Controller of Patents and Designs, Rajiv Gandhi National Institute of Intellectual Property Management, Government of India, Nagpur. Also, Professor Dr. Vikas Gite sir, Coordinator, IPR Cell, Kavitri Vainabai Chaudhary, North Maharashtra University, Jalgaon. Professor Dr. Iramala Dayal, Principal, VT Chokshi, Sarvajanik Law College, Surat, Gujarat. Now, coming to the inauguration, it is my honor to invite Honorable Principal Dr. D.D. Rathod sir to inaugurate this conference. I now hand over session to Dr. D.D. Rathod sir.
Hello.
Yes,
Hello.
sir, you are audible. Audible, sir, yes, you are audible.
Good morning, everybody. आपल्या संस्थेचे संस्थापक अध्यक्ष कैलासवासी कर्मसाक्षी नानासाहेब, माजी मुख्यमंत्री वसंतराव नाईक साहेब यांना सतत वंदन करतो. आजच्या या कार्यक्रमाचे प्रमुख अतिथी उद्घाटक आमच्या शिक्षण संस्थेचे सचिव आदरणीय भैयासाहेब, सोनाबाई शिक्षण संस्थेचे सचिव तथा स्काउट गाईड आयुक्त नंदुरबार जिल्हा आदरणीय ताईसाहेब, आमच्या कॅम्पसचे प्रशासकीय प्रमुख आदरणीय डॉक्टर हिमांशु भाऊ आणि विशेषतः आजच्या एक दिवसीय बौद्धिक संपदा अधिकारी या कार्यशाळेला मार्गदर्शन करणारे तज्ञ प्राध्यापक डॉक्टर सूर्यवंशी सर नागपूर, तसेच डॉक्टर व्ही गीते सर उत्तर महाराष्ट्र विद्यापीठ जळगाव, या सर्वांचे मी सर्वप्रथम स्वागत करतो. आदरणीय कर्मसाक्षी नानासाहेबांनी या संस्थेची उभारणी केलेली आहे. या संस्थेमार्फत कला, विज्ञान, वाणिज्य महाविद्यालयाची स्थापना करून नानासाहेबांच्या या स्थापनेमागे महत्वाचे एकच उद्देश होते की आपल्या परिसरातील गरीब, होतकरू, मागासवर्गीय आर्थिकदृष्ट्या कमकुवत विद्यार्थ्यांना दर्जेदार शिक्षण मिळावे व त्यांच्या उच्च शिक्षणाची गरज ओळखून त्याचे सामाजिक कार्य, शैक्षणिक कार्य इत्यादी बाबतीत प्रगती व्हावी आणि गरीब तळागाळातील गरजू विद्यार्थ्यापर्यंत हे शिक्षण पोहोचावे या उद्देशाने ही संस्था स्थापन केली. प्रत्येक विद्यार्थ्यापर्यंत ज्ञानगंगा अखंडपणे पोहोचवण्यासाठी व त्यांचे महत्वाचे कार्य होते. आज आमच्या संस्थेमध्ये हजारो विद्यार्थी उच्च शिक्षण घेऊन मोठमोठ्या पदावर शासकीय सेवा करीत आहे. त्याचबरोबर आजच्या युगामध्ये आदरणीय भैयासाहेब व ताईसाहेबांच्या मार्गदर्शनाखाली आमची संस्था प्रगतीपथावर आहे. दरवर्षी शिक्षणाचा आलेख हा वाढतच आहे. या उद्देशाने आमच्या महाविद्यालयातील राज्यशास्त्र विभागामार्फत राज्यशास्त्राचे विभाग प्रमुख प्राध्यापक राम हजारी सरांनी बौद्धिक संपदा अधिकार या विषयावर ही कार्यशाळा आयोजित केलेली आहे. या कार्यशाळेमार्फत तज्ञ व्यक्ती म्हणून, तज्ञ मार्गदर्शक म्हणून आदरणीय डॉक्टर भारत सूर्यवंशी सर, आदरणीय डॉक्टर व्ही गीते सर हे आपल्याला अधिक माहिती देतीलच. या माहितीचा सर्वांनी फायदा घ्यावा आणि या कार्यशाळेला माझ्या संस्थेकडनं, माझ्या महाविद्यालयाकडनं ही संस्था यशस्वी व्हावी अशी शुभेच्छा व्यक्त करतो आणि धन्यवाद.
Thank you, sir. Thank you, Honorable Principal Dr. D.D. Rathod, sir, for your inauguration. Your presence and insights greatly contribute to the success of this event. Now, we are ready to deep into our sessions, starting with our first technical session on intellectual property rights. We have with us Dr. Vikas Gite, sir, coordinator of IPR cell KBC NMU Jalgaon. For his kind introduction, I welcome Dr. B.Y. Bagul, sir, to introduce our first resource person.
Okay. I take opportunity to welcome and introduce one of the resource person, a very scholarly, dynamic, and renowned personality in the area of polymer chemistry and IPR, that is Honorable Professor Dr. V.V. Gide. Sir has 21 years teaching and research experience, technical experience 2 years, 2 months as Director of Forensic Sciences, Government of Maharashtra, Mumbai, and industrial experience as 1.5 years. His interest, research thrust areas, micro encapsulation for smart coatings, pesticide formulations, polymer hydrogels, polymers derived from renewable resources, polymer nanocomposites and blends, hyperbranch polymer synthesis. He visited countries like Nepal, Netherlands, South Korea, Mauritius, and Cyprus. Under his able guidance, 16 students completed PhD degree, whereas 4 are working. Also, 2 students are completed MTech degree under his guidance. His research activities are research publications, 70 research papers published, 5 patents are filed and 1 are granted. Presentations in conference, 56 presentations, popular articles 5. He wrote books or chapters in books 10, completed projects 9, Google citations 3041, ongoing projects 2, Google H index 33, and Google I10 index 55. He is serving as a reviewer, life membership of professional organizations, contribution in organizing conferences. He received number of scholarship, prizes, and awards. Sir, having the long CV, but with this brief introduction, I request Honorable Professor Dr. V.V. Gite sir to enlighten on topic intellectual property of light. Professor Dr. V.V. Gite.
पटकन सर.
Over to Professor Dr. V.V. Gite.
Morning, and thank you, sir, for a nice introduction. My thanks are to Hazari sir and Principal sir even for calling me and giving opportunity to interact with so many people and deliver some information regarding IPR startup to you people. I have made this presentation not inclined toward 100% IPR because I know there are more speakers also and there may be overlapping of this. So I have kept it light and introductory. I will talk how IPR can lead to startups and other. So I will start with my presentation here. Sir, is it visible, my screen?
Yes, sir, it is visible.
So we have kept it intellectual property startup and incubation. So this is compilation of my work from my experience and some references, if any. This is normal flow of presentation. I will start with this, that how students are confused in India. We have a lot of population, lot of colleges, and higher education enrollment is increasing day by day, and therefore people are having very less job compared to how many they are passing, and therefore there is always confusion which area, which side I should choose. And the confusion may be because of upliftment of education. If you look at here, population projection in India, we have already touched 1.46 billion here, or 140 crore in 2026, and therefore we have this issue. Second issue is not only population, but as these great personalities like Nelson Mandela, Mahatma Jyotirao Phule, and many other people got the idea how education can uplift anyone's life, and accordingly government is working on that, and that's the reason we have increased a lot of universities, and higher education enrollment ratio is very high. So that lead to production, or you can say availability of technical manpower is more compared to what it is required, and that is one of the reason people have to choose their career very properly, or specifically educational path very properly. So even though they don't like, but they are going for engineering and technology subjects many of the time. That is the reason. So you can compare it with the China. China already started to decline the population, so their issue is reducing, and they have a lot of manufacturing facilities, and therefore their manpower is involved in manufacturing. In our case, we have our manpower involved in the service sector, and we expect near future it is more in manufacturing even. And we will be having our declining population around 250 to 2050 to 2060, and thereafter the population growth will stop. But anyhow, if you look at the people who have born around this 2000 to 2010, they may be seeking for job in the next decade, and that is the issue. So it is obvious to have the confusion for the students. And as a result, in India, getting university admission is a challenge. Whereas if you compare it with international universities, they are struggling to get the student, and so single student they want to grab. So the situation abroad and situation in India is different. Anyhow, this is not the topic of discussion, but just I wanted to get familiar with how this issue is leading to another problem. And if you want to solve those problems, we need to improve our startups. And startups are not nothing but they are totally new material, new manufacturing system, new system. So if you want to have the new system, that need a protection. And right now, people are going for the government job. So this is the normal solution what students or anybody is seeking for. So first priority is to the government job. or sometimes we are going for higher education. In going higher education, we want to have more prospectus for getting the job, or we want to improve the you can say salary and wages of that in that case. And in the government job, we have security, sir. Therefore, people are looking for that. But compared to population now, government jobs are very few or limited, and therefore people have to think of the private job. At least in Maharashtra, people are going for the private job because we have comparatively better industrial sector than other Indian states, and that's why we people are going for the jobs. But other than this, friends, we have many other options for you people. And if you are for the first year engineering, first year BSc, BA, BCom, you are the best to work on the IPR and work on the startups. I feel so. Another jobs are freelancing jobs. Slowly this has gained, and people can do work from home. So this freelancing job you can do as per your leisure time or as per your availability. That's the beauty. Many of these jobs are right now available. And last option goes to the business. It can be small business, it can be large business. And this business can be of different kind. One is a trading. Normally, when we talk about the business, we mostly focus on the trading. Kirana, yeah, kapde ki dukaan, like this, these are trading work. And if you start your business like manufacturing, either as a industry or small factory, so that is different one. Mostly we are not there to do that. We have more risk in that, and here comparatively we have lower risk. But if you are with your own intellectual property, if you are with your own idea, and if you protect that idea, you have chance to start your factory industry. That can be a startup. So that is quite possible. So we will be discussing on similar kind of the topics here. So I will specifically talk on the research related activities. So we are doing this research, and everybody, almost everyone, as at least as per the NEP, it is compulsory to do research even in the BSc, BA, BCom students, because this is now 4 years degree. And during the 4 years, either at the fourth or third years, we have to do some internship and we have to do some projects also. So these bachelor projects are nothing but some research what you are doing. So similarly, we have master projects or master research at the master level. So that is also one sort of research. Then we have voluntary research. Sometimes our students are working voluntarily or helping each other. So there is voluntary research. And in the PhD, we expect actually high level of the research. And yes, of course, we are contributing there. Other than this, in India, it's not big or it's not have big momentum, but it's still working. That postdoctoral research means after PhD, you are searching for job, and government is giving some fellowship sometimes to focus on some important areas. So sometimes these are government-based research fellowships, so we call them as a postdoctoral research. Sometimes industrial research is also involved in the postdoctoral research. Some professor is having industrial project and they want some trained manpower to work on that to solve the issue of that industry. So this is also research. Other than this, we may contribute to other research. Suppose you have limited facility or you have a specific facility and that facility can be availed to others, or if you have limited facility, you can contribute to others research because of your talent and because of your some ideas. So this is how we people are doing research. And at the end, what we have first priority to the publication. Specifically for academic people, this is very common. This is very common that we go for publications. That is normally when anybody coming here, like what Babul sir introduced about me, that this person has there's this number of publication. So we feel proud when we go for publication. Then our priority is to go for book writing. And if this number is sufficient as far as quantity is concerned, then we normally go for technology transfer. And that time we may be thinking on the IPR. So we have reverse order of priorities in academic research. So I will suggest instead to you people that we must have the priority from IPR, technology transfer, and then if it is not possible, this first step, two step, then we can go for publications. Either it is a research publication or book writing. So this is how you can. Now, if you look at the invention, you can define it in some technical language also, but I will simplify it that invention is a unique or novel device, method, composition, or process. Any one of these can be there. You may be thinking that there's an invention should be very unique, so it's not necessary. It can be very small step on the existing device, method, or composition or the process. So you may be altering or you may be modifying existing system. So you don't need to do some altogether different. If it is altogether different, that is a radical invention, and we are not expecting that. Suppose you are working with one machine and you know that machine is producing the product after certain interval of the time, and if you are able to reduce that certain interval of the time, that's also an invention, and that can be patented. So you are increasing the efficiency of that machine, maybe 5%, 10%. Don't expect it will have double, triple. If it is giving double, triple, that's welcome. There's nothing better than that. But that does not mean that 5-10% is negligible. It is still considerable. That kind of inventions also we have to protect. So looking to the research, that is re plus search. I already explained you may invention does not mean that you have to do new things. Here already people have searched, we are researching it. So that is a research. That means the technology, device, method, process is already available, that we just modifying that. Or scientifically we can say it as a systematic investigation into and study of materials and sources to establish facts and research new conclusion. And the overall purpose of the research is to ease the life of human being. Wherever you will go, everywhere you can find this is the bottom line for the research, that we have to ease the life of human being. And there is no limit for doing research. Anyone can do, whether you have the education in that area or not. That does not matter on whether you should do or not. You can see here, here I have put two examples. These are photographs taken by me during my one visit to one farmer. He is from Raver Tahsil, and this is for turmeric preparation. You know that crude turmeric normally cannot be sold in the market. Rather, it is some cooked and they are peeling out, and that dried and cooked peeled out turmeric is available in the market. So this is very hard job to convert that raw or crude turmeric into the final form. So that I have experienced that we were cultivating it. That's why I know the pains in that case. So he solved that pains just by taking one boiler. It's not actually boiler. He designed it very simply and designed these drums. So almost from the raw or waste material he prepared and this cooking device he prepared. Now it is not in working condition. In this picture, as when I visited that time, it was out of season. But when season will start, he will restate it and will start to work on that. So you can find this kind of research is also possible, and this is not done in the by the person who is expert in that area. So he's expert in agriculture or farming, whereas he has work in mechanical or you can say instrumentation, machining, engineering part given. So this is how you can do research, and this research should be protected. If you don't protect, you cannot have maximum financial benefit of an idea which you have invented or identified. So you need to protect that idea with the help of intellectual property rights. Now I have shown that part. I have shown that part here. Now this scene can be repeated by anyone without the permission of that farmer, and that time that farmer will not have financial benefit of this design. Rather, if he has protected this IPR of this part, then he would ask you to pay something as a royalty to him against the copying of the design, copying of his machinery, copying of everything. So this is how you can protect your idea by IPR, that is intellectual property right. Intellectual property right is your right that has arrived from against the what you have developed. So if you look at the picture here, nowadays we have that war. Earlier we used to have the war will happen because of petrol. Now then we started to talk war will happen because of water. Then we started to talk the war will happen because of money. So you can find this is the list of countries uh, from top income side that United States is having around 26 or 27 trillion dollars. China is having around 19 trillion dollars. Japan is having 4.4 trillion dollars. Germany is 4.3 trillion dollars. India is 3.7 trillion dollars. Like these numbers you can see. Now India is above the Japan, and Germany is the third. India is fourth and Japan is fifth number economy in the world. Point is not that who is at this position recently. Point is the countries which you are seeing here in the right hand side of the slide, you can find them in the left hand side similar. And this is because these people are filing more and more patent, and that's why you can find China and US are filing more, and that's why they are having very high level of income compared to other countries. Of course, we are also in the first sixth number of patent filing country. But this is not sufficient because we are not comparing with Germany, Japan, or Republic of Korea because these are so small countries. Their population is limited. So I hope we should compare ourselves with the China. China is having almost 1.46 billion population as compared to India. It is almost similar number of people they have, but their number of filing is around 16 lakh patents, whereas we are somewhere less than 1 lakh. So around 71,000 patents we filed in this area. And again, if you look at this dark color is residential filing and non-residential filing. In China, residential filing is there, means Chinese people are filing more patent in their country than other people filing in the China, whereas in US it is opposite. And in India, this is we are fortunate that this year we have equal, and later on in I think this data is 2023's data to 24-25 we filed more patent by residential people than the non-residential. Residential means domestic filing, means Indian people are filing in India. That is more important because when Indian people is filing, are filing patent in India, that means they are developing their indigenous technology. And when foreign people are filing in India, that means they want to protect their technology in your country. They want to sell their product in your country. And if they want to sell that, it should not be copied in your country. And if it is copied, their all invention, all efforts to do that invention are nullified. So what they want protection for their product. So you can find Chinese people are selling their products in India. If they are selling their products and if they want to protect it from copying, they have to take care of it, and that's the issue. But now we are filing more patents in India. Here you can find recently there is a tremendous jump in filing of the patent all over the world. These are first 5 number patent filing countries or unions. This EPO is European Union, and that's why remainings are the individual country. So even small country like Korea is filing more patents, Japan is filing more patents, but this is declining in the Japan, and that's the reason their economy has reduced and they have dropped down to the 5th number, and we are now at the 4th number in terms of top 10 economies or top economies of the world. So my appeal to everybody is, if we are doing research, but we are unable to file patents, we are unable to actually grab financial benefits of this. See, friends, initially you may be thinking that, sir, in our college we have filed so many patents, but none of them is commercialized. Yes, your question is correct. What you are thinking, that is perfect, but there is I can share you this that if you are filing more patent, that means you are going on the quantitative level. So this is the first step. In next step, when you will be sufficient to file the patents, you will go for the commercialization of this. So that is a qualitative one. So first, normally we are going for quantity, and then we are going for quality. So I hope that we are in the phase of quantity right now. So very soon we will be thinking on the quality. So at least whatever is possible, whether it is quantity or quality you go for filing, give the priority for filing of the patent. And for filing of the patent or filing of any invention as an IPR, so you don't require any education. Any person can file the patent. You will be surprised. I can tell you, one person came to us. He was just a 5-6 standard person from one of the village, and he approached that, sir, I have invented one cooler and I want to protect it. And we help him. His patent will be filed very soon. So he's not educated in that area. Even he's not 10 plus pass or something like. So you can think of uh, filing of the patent of yourself or others also. So here, just I summarizing that it is intellectual property right is a right for your invention. That exclusive rights given to person or legal entity. Here it can be for individual person or legal entity means organization. It can be industry or some research organization over the creation of minds for certain period of time. That means if you have developed some system and if you are taking IPR of that, then particular government will give you that right, that where you have filed, that accordingly that government will give you right. And this right is not for lifelong because they know that this right should be given only for the limited time. So you can have monopoly in that limited time. But thereafter it is open to everyone. Normally for patent it is 20 years. And for others it is depend. So this is a fair reward to your intellectual property because it is generated by you. Hope that farmer has protected it. So it would not have been issue to him. Of course, he has not faced any issue because that is not required in large quantity. But no one can deny that in the tomorrow people will not copy it. And these are different types of IPR. Normally, we think that IPR is only of the patent kind, but no, it's not only of the patent kind. They can be of patent, copyrights, trademark, trade secret, industrial design, geographical indication. These are important types of IPR, what I have shown here. So patent, copyright, trademark, trade secret, industrial design, and geographical indication. So if you look at all this, so there are some importances in this case. Geographical indication is one sort of IPR that cannot be obtained by individual, but it can be obtained only by some NGOs. Whereas if you look at others, I will compare trade secret with others. Trade secret cannot be registered. It has to be kept secret, whereas others can be registered to the government. So these are some important aspects in the types of IPR. So what is patent? So this is a legal right to protect an invention from unauthorized manufacturing, selling, imitating or importing for commercial purposes. This, you are not only limiting or you are protecting your invention for from unauthorized manufacturing. Means without your permission, no one should uh, manufacture it. Even they should not sell it or imitate or import for commercial purpose. And the validity of patent is normally 20 years. After 20 years, it's open to everybody. And you may be thinking, sir, I am having one Indian patent. Will it be valid all over the world? No. It is a territorial right because each country, US has different, each country has different laws. In US, you may have patent for one X, but for the same invention, you may not have in India because the patent laws are different. Patentability systems are little variable and therefore patent granted in one country is not valid in other country. So we normally call in technical language, it is a territorial right. And as such, there is no provision for international patent. And that's why we don't have one single patent for entire world. So wherever you want to approach, you have to file the patent. Suppose you have done patent filing in India, and if you want to sell it in China, so you need protection in China even. So that time you have to go and file patent in China even. And if you have patent in China, it don't have any value. So sometimes people are saying that I am having US patent, you are having Indian patent. No, no patent is great. All are equal in their country only. Otherwise, they have almost zero value. And if you ask me, sir, for patent, what you need to have, so which kinds of invention can be patented? So normally patents can be granted to article, device, or machine, or process, and sometimes for combination of chemicals. But this combination of chemicals should be with some synergistic effect. Means 1 plus 1 is equal to 2. This one chemical is giving one property, another chemical is giving another property. And at the end, by mixing them, you are getting only two property. So you cannot file patent. But if 1 plus 1 is equal to greater than 2, means if another materials efficacy is increasing by presence of second material, so you can have that patent also. So normally device, article, machine, then process and combination. These are the three things for which we can have patent. And for other invention or other your intellectual property, you have some other kinds of IPRs. So if you look at here, this is the filing process. You can file a application. It is if you are in hurry and you are not sure that whether it will be copied or not. So you have two options here: file patent provisionally, because filing is very important. First to file, first will, and that the person who will file first will have the first right to protect, and therefore you should rush for filing of the patent. And if you are not sure whether it will be copied or not, so you go for the whatever results are with you, you take that and go for provisional patent. And if you have all results in your hand, then you go for complete specification. Normally you get a 12-month period from switching from provisional to the complete specification. And here these online forms are available. Process is entirely online, so you can do it from home. Thereafter, it will get published after 18 months. So it will be open to anybody. So anyone can have objection on this. And then it will be taken for examination. Examination means here people sitting in the office, government office, patent office, they will search for it, whether it is already patented by somebody or not, or whether it is published or not. Because here criteria is that it should not be published. It should not be available in the public domain before filing of the patent. And if it is available in the public domain, then no one can file it. So they will examine it, and based on that, they will generate one report. How we are generating report for or getting report for publication. Similar report they will generate and give to you, and you have to answer that report. This is already, they will give you. You have 10 claims. Out of that 10 claims, 2 claims are already covered in X, remaining 2 are covered in Y. Like this, they will give report, and you have to compare your claims and the document suggested by patent office, and you have to give reply to them. ये कैसा अलग है या तो how you delete that your claim, and then your patent will be accepted, and then it will be granted. So this is a long procedure. Don't expect it should be very fast. Normally people are confusing when they publish, they say हमारा patent हो गया. No, a publication is possible for every patent. Another confusion in case of patent is people are going for industrial design and they are saying हमारा patent हो गया. No, patent is different, industrial design is different. They are calling that as a design patent, and this regular patent as a utility patent. In India, we don't have utility and design patent system. We have patent is a patent, design is a design. Don't confuse. Design only is the certificate format is same, and therefore people are confusing. So let me clear to specifically for academic people. Then we have another kind of IPR, that is copyright. Normally it is for writing material, original literary work, dramatic work, musical work, artistic work, computer software, and the validity of this is lifetime of that author or creator plus 60 years after the date of the author. So you can find here some ideas which can be patented. Normally, being academicians, we are going for publications. So publications are having copyright. How many publications you have, that much copyright have already been generated. But in maximum cases, which are not paid journal, there the copyright is with the journal. In open access, copyright may be with you or maybe with that journal. So you have already, almost every teacher have already gone through the IPR. The only thing is we are unaware that what we have done, that is IPR on. But you can earn the money. There are so many people who has prepared they literally work and they are earning a lot of money also. These are some examples. You can find Chetan Bhagat's or even Lata Mangeshkar's creations. So these all are coming under the category of copyright. Then we have trade secret, trademark. So immediate after looking this, something comes in our mind, and that is your logo. So if logo is there, that means if it is famous, that means you have done a lot of work, you have taken a lot of pain, efforts, and thereafter you are famous among the people. You have earned some goodwill in the people, and that goodwill, if copied by others, then it can be setback to your business because it will drop down your business. Second, their quality may be inferior, but they may be competing with you. And to avoid that, we need to take the trademark as a IPR of this. And India is one of the leading countries. Means we are at the third position in registration of trademark. So this is the right thing what we are doing. So once trademark we found, suppose you found some this kind of trademark, then you know very well that this sign indicates the quality. This sign indicates the quality or consistent result, and that's based on that we are purchasing the material. So that is why nobody should copy your trademark and you have to register it. Then we have trade secret. I already mentioned trade secret cannot be registered. But the difference is there are some invention which can be patented, which can be considered as a trade secret. So you may be thinking, sir, if it is patentable, then why don't we go for trade secret? Why we are going for trade secret? Because trade secret is not limited by 20 years. Not limited by 20 years. So we have to go for trade secret. Then why we should not go for the patent? We should go for the patent. Even though it is for 20 years, trade secret has problem that it is not registered and it has to be with you people. And if it is open, then you cannot control it. And that is why you have to decide. Normally, when we have invention, which will be absolute after 20 years, so we have to select the patent. But if it is not going to absolute, like your example is given here, KFC chicken or Coca-Cola recipe, these are not absolute till today, even though they invented long back, maybe 20 years, 40 years, 60 years back. So that time we have to go for trade secret. In other case, you can find experimental results, survey methods, financial strategies of that company, client databases of those companies. These are not patentable. But what you can patent, manufacturing process, recipe, chemical formula, these are patentable. But still these can be considered as a trade secret. It depends on whether they are going to absolute after 20 years, you go for patent. But if they are not going to absolute, like your formula here, chemical formula means your Kentucky's Fried Chicken's formula, Coca-Cola's formula, that is not going to absolute, and therefore here they have taken the trade secret. But this experiment results, survey method, financial strategy, or client databases cannot be patented, cannot be have IPR by other methods, so you protect them. Even colleges can go for trade secret if they have some financial strategies or some client databases. So it should not be available to your opposition's hand. So these are some examples, and we are happy that we supported on Kesh Kanchan hair oil for getting their trade secrets. Is a self-help group startup industry. That lady approached to us, sir, I want to file a patent. So after going in detail, we got that key. Instead of going for the patent, we should go for trade secret, and we register our trade secret for Kesh Kanchan hair oil. It is especially important for growing hair and to stop the hair fall. Yeah, this was what I was talking about. What is an industrial design? Industrial designs are finished articles appeal that can be judged solely by the eye. This from long, if you have some machine or object kept there and people will, oh, what a beautiful it is. That means your industrial design. It's aesthetic look. The aesthetic look is not improving the performance. It is just improving the look. So that can be registered as industrial design. Nowadays, academicians are confusing in industrial design and patent. They are registering industrial design. Industrial design we can have in the 6 months, and it's a design. It's not patent. Patent is for machine, device, process, and formula. And industrial design is for only for aesthetic look, and it can be copied easily even. And that is why people are registering. Industrial design registration is very vast in India. Slowly we got that momentum for trade secrets, trademarks and industrial design. So don't confuse in industrial design. Only the similarities. Patent office has made all IPRs to be given on the same certificate format, and therefore confusion has increased especially in North Maharashtra region. I saw it, but whenever I get or I came across this, I reported to the people that it's industrial design. The last one is geographical indication. We know this is Kolhapuri chappal, and this Kolhapuri chappal has to be manufactured only by Kolhapur chappals manufacturer associations, not by other member, because they registered it as a geographical indication. And I mentioned you, geographical indication is geographical area specific material. It can be manufactured or it can be a crop cultivations like that. And this is not property of individual, and therefore individual cannot register. We have some other example, that is Darjeeling tea, Alfonso mango, Mysore pak. Even our North Maharashtra region has three different system. One is Jalgaon banana. We know very well that Jalgaon banana is famous all over the world. Other is Jalgaon brinjal, that is also famous, and Nawapur tur dal. So this is registered by Bali Raja Krishak Bachat Gat Taluka Nawapur, and they are getting almost double price to this product because they have registered, and that cannot be cultivated by others with the name Nawapur tur dal. This has to be cultivated by the members of Bali Raja Krushak Bachat Gat. Similar is the case with Nisarg Raja Krushi Vigyan Kendra and Navnirmiti Shetkari Mandal. So their members can only say it's a Jalgaon Brinjar or Jalgaon Banana. So that's the beauty of geographical indication. We have high potential to register geographical indications in India. And right now we have only 600 geographical indications all over the world, India. And government has put this target to 10,000 by 2030. So we have vast number of registration yet to come in geographical indications. So this was about the IPR. Now, if you don't have IPR, can you start your business, or whether you required IPR in starting the business? So option is yes. Without IPR, you can go for an option to no. If this option to no is normally, if you have your own invention, you have to go IPR and then start the business. Otherwise, it will be very high chances that people will copy your business. People will not look towards you unless you are successful. Once you are successful, people will easily copy because it is already validated in the market. You have already developed that product. And now, if they copy, they will sell it in the low cost because they have not spent money on R&D. They have not spent time on R&D, which you have spent, and you want to recover that. So if you want to recover that, you will put the value of that material little more than what actual common man can give, and therefore you have chances. Even though if you want to start a business, if you want to start a startup, without having IPR, you can use earlier patents without infringement. If you use another's patent without his what you can say permission, that is called as infringement. But you can use it when the patent's validity is expired, if it is already 20 years over. So you don't need to start from scratch. You take their patent, You try to make your product based on that 20 years expired patent and then modify it. When patent is lapsed before 20 years, sometimes people are not paying fees. Patent is not only that you will grant it and you feel that now 20 years are secured. No, every year you have to pay government fee. And if you are paying government fee, then it will be valid. But if you are not paid, then there is chance that it can be lapsed before 20 years. So you can use such patents. When patent is not filed in your country, if it is filed in some other country, you can copy some part of it. And even if it is not possible first for, then get license of the existing patent and you can. But everything is attached to IPR. And for your own invention, you don't have option. You have to file patent. If you don't file patent, if you don't take IPR of that, there is chance that it will be forfeit. So if you want to start business, then you require money, factory side, machine, staff, technology ready, many permission, legal support. And if you want to maintain all this, you require 1 to 2 years, and later on you come to know that your business is successful or fail. If it is fail, everything is in the loss. So instead of doing such a business, you approach to incubation centers with innovative ideas. They will provide you all support, what I mentioned earlier, and they will bring you to up to scale up process, and then you can do your business independently. This is how the cycle in the case of incubation centers is. So if you have IPR, if you have an idea, first go for IPR and then I approach to incubation center, or approach first incubation center and do the IPR of that. So this is just one picture of incubation center present in our Jalgaon, that is KCIL, KBC NMU Center for Innovation Incubation Linkages, where you can have specialized facilities, product development and testing facilities. You can have some grants, patent IP support is available to you. Some technical and business mentors are available to us. We will be having industrial and government connects to the center. So this is how you can start your business. And there is no criteria actually, age, relevant education, region, innovative. You only need an innovative ideas. And normally many incubation centers are keeping their call open 24/7. So I think with this, I will stop here, that this is the process normally when you have idea to incubation centers entry. So I will not talk much on this, but I will stop here. But before I stop, I will bring one example in front of you, that this is the person, Dr. Sandeep Patil, who is management council member of our university. He was a BTech student and now he started his industry. It was a path like IPR, incubation center, startup, and now a successful businessman. You can find here on the front page of this Silicon India, his photo is published, and Modi ji is wearing his N95 mask. He is the first person or industry to manufacture N95 mask in India. So this is started from the scratch because he was with some intellectual property. So this is another person who is also successful startup with us. Our MSc student started his own industry. These are some successful people's example. And I will stop here. I thanks to you all for patient listening. And I am thankful to the college even for calling me and giving chance to interact with you people. Over to you, sir.
Okay, sir. Thank you, sir. Thank you so much, sir, for your insightful session. Sir, you gave all our participants information about invention, patent. You you explain these concepts in very simple and detailed manner, sir. You also gave us information about trademark and geographical indicators. Sir, I would like to congratulate you for your contribution in the formulation of Kesh Kanchan hair. And we- congratulations, sir. Now for the uh, vote of thanks of this session, I would like to invite Professor Padgan, sir.
Sir, just a minute. I have taken superficially because other speakers will talk more detail on the IPR. That's why I touch with the startups and academic system here.
Okay, sir.
Thank you, sir. Respected chief guest, today's resource person, Dr. Vikas Gite, sir, Honorable Principal, respected faculty member, and dear students. On the behalf of the organizing committee, it is my privilege to propose the vote of thanks for today's National E-Seminar on Intellectual Property Rights. First and foremost, I extend our heartfelt thanks to respected Dr. Vikas Gite sir for delivering such a nice information and enlightening session on intellectual property rights. Your valuable guidance on patent, copyright, uh, trading patent application, invention, trademark, trade, trade secret, geographical indication, industrial design. They are very nice information in our intellectual property rights and your valuable guidance on this uh, IPR. Your practical example and clear explanation made the topic easy to understand and very interesting. I also express my sincere thanks to Honorable Principal for constant support and encouragement in this academic program. My gratitude to all the faculty members for the cooperation and presence. Special thanks to organizing committee, head of the department, political science, Professor Ram Hazari sir. Thanks to Dr. B.Y. Bagul sir, Professor S.A. Pavra sir, technical support, Dr.Sahebrao sir, Dr. Barpe sir, Dr. Anil Patil sir, for their hard work and dedication in making this seminar successful. Lastly, I thanks to all students for their active participation and attentive listening. Once again, thank you, Dr. Vikas Gite sir, and thank you to everyone for making this National E-Seminar for grand success. Thank you. Thank you.
Thank you, sir. Now, dear participants, for the second session of the conference, we have special guest with us. Let me give you a brief introduction to our resource person, Dr. Iramala Dayal Madam, a versatile personality and a great academician. She is the principal in charge of VT Choksi Sarvajanik Law College, Surat, and a first rank holder and gold medalist in LLB and LLM. She holds a PhD in law, along with multiple degrees, including BSc, B.Lib, UGC NET, and GSET. With over 25 research papers published in reputed peer-reviewed journals and conference volumes, she has also co-authored 3 books and edited 2 ISBN registered publications. Dr. Iramala Dayal is the editor of Sarvolokam Law and Society, a multidisciplinary national peer-reviewed journal. She is the chairperson and pioneer of the research center at the Vittichoksi Sarvajanik Law College. She has completed a state-funded minor research project and is currently leading a UGC-sponsored study. As coordinator of the UGC MMTTC Faculty Development Program on NEP 2020, Orientation and Sensitization, she received the Best Coordinator Award. A dedicated academic leader, she organizes annual legal literacy camps, coordinates multiple certificate courses, and serves as the convener of numerous academic conferences and seminars. She is also a recipient of the Sarvajanik Shikshan Ratna Award for excellence in legal education. 2 research scholars have been awarded PhD in law under her mentorship. She is currently working on 2 research projects awarded by ICSSR and KCG. She is the coordinator of refresher course in collaboration with UGC MMTT Jodhpur. Thus, we feel very lucky to have Eramala Dayal Madam as our resource person. Now I hand over session to Dayal Madam and request Madam to guide our participants.
Thank you, Professor Ram, for such a gracious introduction. कुछ ज़्यादा ही बोल दिया आपने, but I'll try my best to justify your expectations, and lots of gratitude for inviting me on this platform. Friends, मेरा tentative presentation आज intellectual property rights related है. I understand in forthcoming sessions में डिटेल में डिस्कशन डिफरेंट फॉर्म्स ऑफ इंटेलेक्चुअल प्रॉपर्टी राइट पे होगा. तो यहाँ थोड़ा नेशनल लीगल रेजिम रिलेटेड टू इंटेलेक्चुअल प्रॉपर्टी राइट्स एंड इंटरनेशनल लीगल रेजिम रिलेटेड टू इंटेलेक्चुअल प्रॉपर्टी राइट्स उस पे हम डिस्कशन कर लेते हैं. With your permission, Ram sir, I'll share my screen.
Yes, madam. Yes, madam.
Oh God, allow screen recording. Okay, just a minute. Just a minute, sir. मैं आपको भेज दूं सर पीपीटी शायद यहाँ से कुछ. Can you share from your? Because यहाँ से मैं शेयर नहीं कर पा रही हूँ.
Okay, madam. Okay, madam.
Just a minute. Sir, I've shared my PPT with you. अगर आप शेयर कर पा रहे हो तो अच्छा है. Friends,
Okay, madam.
Before we begin, can any of you tell me what do you understand by intellectual property right? Any one of you? कोई भी पार्टिसिपेंट इंटरेक्ट करना चाहेगा कि बौद्धिक संपत्ति के अधिकार का मतलब क्या है? Any one of you? Friends, मेरा इंटरेक्टिव सेशन रहता है. Okay, fine. I will only continue. Specialized Agency of United Nations Organization has very tentatively given a very inclusive definition of intellectual property right. IPR आपके वो rights हैं जो because of your creativity आपको मिलते हैं, because of your intellect आपको मिलते हैं. So we can talk about definition of intellectual property as proposed by World Intellectual Property Organization. अभी क्वेश्चन ये आता है कि are these rights your corporeal rights or incorporeal rights? क्या ये जो अधिकार हमें मिलते हैं वो मूर्त अधिकार है या अमूर्त अधिकार है? कोई इंटरेक्ट करना चाहेगा this related? Okay. When you talk about property and you talk about corporeal property, तो हम उस property की बात कर रहे हैं जिसका कोई physical form हो. और जब आप incorporeal property की बात कर रहे हो तो उस property की बात कर रहे हो जो corporeal नहीं है, which cannot be perceived by your senses. जब भी आप इनकॉर्पोरियल प्रॉपर्टी की बात कर रहे हो, अभी मैं कॉर्पोरियल प्रॉपर्टी में डिटेल में नहीं लूंगी. इनकॉर्पोरियल प्रॉपर्टी की जब हम बात कर रहे हैं तो हम कभी मॉर्गेज की भी बात कर सकते हैं, कभी सिक्योरिटी की भी बात करते हैं, पर आज हम सिर्फ इंटेलेक्चुअल प्रॉपर्टी की बात करेंगे. और अगले सेशन में मैं टुवर्ड्स द एंड ज्वाइन हुई थी तो आई हर्ड समथिंग रिलेटेड टू ज्योग्राफिकल इंडिकेशंस, ऑफ some discussion on patents, some discussion on copyright, etc. जो मैं फ्रेंड्स इंटेलेक्चुअल प्रॉपर्टी की बात कर रही हूँ यही है. क्रिएशंस ऑफ माइंड, इन्वेंशंस, ऑथर्स, सिंबल्स जो ट्रेडमार्क की हम बात करेंगे, नेम्स एंड इमेजेस यूज्ड इन कॉमर्स. तो आप में से आई थिंक सबको ही पेटेंट्स के बारे में बेसिक इंफॉर्मेशन होगी, कॉपीराइट के बारे में बेसिक इंफॉर्मेशन होगी, ट्रेडमार्क के बारे में भी होगी। आई होप सो। पर एक चीज हमेशा ध्यान रखनी है कि पेटेंट्स आर फर्स्ट कम फर्स्ट सर्व्ड। इफ यू हैव इन्वेंटेड समथिंग और आपने अप्लाई किया है और अगर आपकी एप्लीकेशन पेटेंट ऑफिसर्स ने अप्रूव की है, then you might be awarded a patent, provided आप दूसरे क्राइटेरिया फुलफिल कर रहे हो। पर कॉपीराइट में it is not like that. Copyright is available when you create something. दो जन एक ही थीम पे पेंट कर रहे हैं, दोनों ने एक दूसरे का पेंटिंग नहीं देखा है, दोनों को कॉपीराइट साइमल्टेनियसली मिल सकता है, उसमें फर्स्ट कम फर्स्ट सर्व्ड नहीं लेना है। पेटेंट्स में you have to apply for patent. Then only if it is approved will be given a patent. Copyright में as soon as your creation comes into existence, you automatically get copyright on your work. तो ये basic difference पकड़ के समझ के आगे चलना है। राम जी नेक्स्ट स्लाइड प्लीज। ओके, कॉपीराइट की बात करें तो इट ऑल्सो इंक्लूड्स लिटरेरी वर्क्स, novels, books, poems, plays, movies, everything over here. Drawings, paintings, photographs, sculptures, even architectural design. Friends, मैं अभी एक रिसर्च पेपर पे काम कर रही हूँ. It is at present a working paper, जिसमें मैं इंटेलेक्चुअल प्रॉपर्टी राइट्स ऑफ आर्किटेक्ट्स उस एरिया में काम कर रही हूँ. और ये जरूरी नहीं है कि यू हैव कॉपीराइट एक्ट 1957 उसके बाद ही आपको ये इंटेलेक्चुअल प्रॉपर्टी राइट प्रोटेक्शन मिला है. नो नो नो. इफ यू रिफर our Vedas, if you refer our Vedangas, if you refer our Upvedas, if you refer our Dharma Shastras, तो आर्किटेक्चरल डिजाइन का प्रोटेक्शन आपको महाभारत में भी देखने को मिलेगा. आपको आर्किटेक्चरल डिजाइन रिलेटेड जो भी डिस्कशन है वो आपको रामायण में भी देखने को मिलेंगे. सो ये जो रेजिम है अभी प्रॉपरली कोडिफाई हुई है, दैट आई फुल्ली एग्री, पर उसके रूट्स हमें कहीं ना कहीं हमारे वैदिक स्क्रिप्चर्स में दिखने मिल रहे हैं. सो नेक्स्ट स्लाइड प्लीज. ओके, अभी हम इंटरनेशनल लीगल रेजिम रिलेटेड टू इंटेलेक्चुअल प्रॉपर्टी की बात करें तो when you talk about industrial property, you talk about Paris Convention. And Paris Convention deals with patents, it deals with trademarks, it deals with geographical indications also. और जब हम बर्न कन्वेंशन फॉर प्रोटेक्शन ऑफ लिटरेरी एंड आर्टिस्टिक वर्क्स की बात कर रहे हैं, इट बेसिकली डील्स विद कॉपीराइट. और फ्रेंड्स, आज ये दोनों इंटरनेशनल कन्वेंशंस they are being administered by specialized agency of United Nations organization, that is World Intellectual Property Organization. Next slide please. Okay, अभी हम थोड़ा पेटेंट कॉपरेशन ट्रीटी की बात करें और वाइपो कॉपीराइट ट्रीटी की बात करें. Anyone of you will like to interact with me related to Patent Cooperation Treaty 1970? Anyone of you? अपने आप को अनम्यूट करके आप बोल सकते हो या मैसेज बॉक्स में मैसेजेस छोड़ सकते हो. Friends, can anyone tell me, is there anything such as international patent? Anyone of you? आज के ज़माने में patents are territorial rights. There is nothing such as international patent, friends, today. जब हम PCT की बात कर रहे हैं तो हर एक मेंबर कंट्री ऑफ PCT के लाइक यहाँ एक रीजनल ऑफिस होता है और आप वहाँ एक पेटेंट एप्लीकेशन फॉरवर्ड कर सकते हैं। आपने कुछ बहुत अच्छा इन्वेंट किया and you feel that you need patent protection of that invention in your domestic country, that is India, and also simultaneously in other member countries of PCT. तो आप एक इंटरनेशनल एप्लीकेशन पीसीटी का ऑफिस जो उस कंट्री में हो, इंडिया में जहां हो, वहां कर सकते हो। And you can in that application only request for simultaneous protection of your invention in other member countries. जरूरी नहीं है कि जितनी भी कंट्रीज है सभी जगह आप पेटेंट प्रोटेक्शन मांगो। इसमें से आप 2-3 कंट्रीज भी सिलेक्ट कर सकते हो या कोई और एक भी सिलेक्ट कर सकते हो। अभी पीसीटी का फायदा क्या है फ्रेंड्स यहाँ पे कि आपको बार बार एप्लीकेशन दूसरी कंट्री में नहीं करनी पड़ती। जितने मेंबर कंट्रीज हैं एक सिंगल इंटरनेशनल एप्लीकेशन से आप मूव कर सकते हो। यहाँ आपका टाइम बच जाता है, एप्लीकेशन का कॉस्ट भी बच जाता है। दूसरी बात, ये भी कोई गारंटी नहीं है कि सपोजिंग आपने एक एप्लीकेशन दिया इंडिया के लिए, दूसरा एप्लीकेशन दिया यूके के लिए, तीसरा दिया जापान के लिए, तो इंडिया ने पेटेंट दे दिया तो यूके और जापान भी दे देंगे। नो, पेटेंट्स आर टेरिटोरियल राइट्स। और अगर जिस कंट्री में मेंबर कंट्री में आपने एक ही एप्लीकेशन थ्रू अप्लाई किया है, उस मेंबर कंट्री के स्टैट्यूटरी प्रोविजंस, लीगल प्रोविजंस अंडर आप फॉर पेटेंट एलिजिबल होते हो तो आपको पेटेंट मिलेगा। Otherwise you will not be getting a patent. Otherwise you will not be getting patent. One country might give you a patent, and for same invention, if you do not comply with the statutory provisions of other country, they will not give you a patent. इंडिया में भी ऐसा एक केस हुआ था। किसी को पता है कि कौन सी ड्रग यानी मेडिसिन फार्मास्यूटिकल रिलेटेड केस है कि 40 कंट्रीज ने पेटेंट्स दिया था और इंडिया की सुप्रीम कोर्ट ने मना किया था, पेटेंट हमने नहीं दिया था। किसी को पता है उस बारे में? एनीवन ऑफ यू? अगर आपको नो, अनिल जी आप सिर्फ एक्टिव है, बाकी सब अपने को लर्नर्स को भी मोटिवेट कीजिए, थोड़ा इंटरेक्ट कीजिए। अनिल जी इसके लिए आएगा नोवार्टिस एजी वर्सेस यूनियन ऑफ इंडिया। ये जजमेंट हम डिटेल में नेक्स्ट स्लाइड में लेंगे, बट इतना कह दूं कि नोवार्टिस एजी वर्सेस यूनियन ऑफ इंडिया में 40 कंट्रीज ने ग्लीवैक एंटी ब्लड कैंसर ड्रग which was manufactured by Novartis, which is a Swiss drug manufacturing giant, उसको पेटेंट दिया था। इंडिया की सुप्रीम कोर्ट ने placing reliance on Section 3 subclause D of Indian Patent Act 1970 नहीं दिया था, बिकॉज इंडिया में ब्लड कैंसर के पेशेंट्स की फ्रीक्वेंसी रेशियो नंबर ज़्यादा है और 3D हमारा सेक्शन 3 सब क्लॉज डी उसकी अनुमति नहीं दे रहा है। Then we will be discussing in detail. So what I want to explain over here is friends कि एक कंट्री पेटेंट दे, जरूरी नहीं सभी कंट्रीज उसको पेटेंट देगी। इवन दो यू हैव मूव्ड अंडर इंटरनेशनल एप्लीकेशन in tune with Patent Cooperation Treaty 1970. Any doubts over here or shall I move forward? किसी को कुछ पूछना है? एक्चुअली पिछली साइड पे ही हम जाएंगे राम सर। अभी मेरा वाइपो कॉपीराइट ट्रीटी का डिस्कशन बाकी है। जब हम वाइपो कॉपीराइट ट्रीटी की फ्रेंड्स बात कर रहे हैं, दिस आल्सो रिलेट्स टू कॉपीराइट प्रोविजंस। जो प्रोविजंस बर्न कन्वेंशन में इंक्लूड नहीं किए गए थे वो सब WCT ने कंप्यूटर्स और सॉफ्टवेयर और सबके रिलेटेड कॉपीराइट प्रोटेक्शन इन डिजिटल मीडियम यहाँ टेक केयर किया है। Yes, Ram sir. Now, please, can we move forward? Sorry to bother you, पर पता नहीं आज क्यों नहीं मैं मैनेज कर पा रही हूँ।
नो मैडम, नो प्रॉब्लम।
Okay. अभी पेटेंट की बात कर रहे हैं। आपका एक सेशन IPR पे हो चुका है, दूसरा डिटेल में होने वाला है। Can any one of you tell me what do you understand by patent? Any one of you, what is the meaning of patent? Yes, WTCT is in context of IPR, WIPO copyright treaty, and it focuses mainly on copyright and it talks about digital copyright also. Thank you, Vasant Raoji. Thank you very much for your message. Can any one of you tell me what is the meaning of patent? किस inventions के लिए patent मिलते हैं? Any one of you? फ्रेंड्स, इतना पकड़ के रखना कि पेटेंट हमेशा इन्वेंशन के लिए ही सरकार अवार्ड करेंगे। पेटेंट कभी भी डिस्कवरी के लिए अवार्ड नहीं होते हैं। So you should be very precise about what is an invention and what is a discovery. Yes, Anilji is very right. Patent is official right to be the only person to make use sell product invention. Fine. अनिल जी के मैसेज को हम थोड़ा इलाबोरेट आगे फ्रेंड्स करते हैं कि एक तो बेसिक क्लैरिटी हम सब में है कि पेटेंट्स आर अवेलेबल ओनली फॉर इन्वेंशंस एंड नेवर फॉर डिस्कवरीज। तो ये बात समझने के लिए एक एग्जांपल ले लेंगे कि व्हाट इज एन इन्वेंशन एंड व्हाट इज अ डिस्कवरी। इन्वेंशन के लिए हम शायद अलेक्जेंडर ग्रेहम बेल का एग्जाम्पल ले लें कि ही इन्वेंटेड टेलीफोन और यूएस ट्रेडमार्क एंड पेटेंट ऑफिस ने उनको टेलीफोन के लिए पेटेंट दिया। और यहाँ आप फर्स्ट कम फर्स्ट सर्व्ड मैंने जो बोला था वो बात भी कर सकते हो। एलिशा ग्रे भी टेलीफोन के इन्वेंशन पे ही काम कर रहे थे। एक कंट्रोवर्सी ऐसी है कि शायद एलिशा ग्रे ने पहले टेलीफोन इन्वेंट किया, वो लेट पहुंचे और समहाउ अलेक्जेंडर ग्रेहम बेल ने कुछ वहां मैनेज करके ले लिया। दूसरा ये कह रहे हैं कि अलेक्जेंडर ग्रेहम बेल डिजर्विंग ही थे और एलिशा ग्रे को मिला नहीं पेटेंट, इसलिए उन्होंने उनको बैड माउथ किया। वी डोंट नो, बहुत पहले की बात है, कोई ऑफिशियल रिकॉर्ड नहीं है। But 2 people were working on telephone, Alexander Graham Bell as well as Alicia Gray. And Alexander Graham Bell first पहुंचे, first apply किया और उनको टेलीफोन के लिए पेटेंट ग्रांट करने में आया। आगे फ्रेंड्स बात करते डिस्कवरी की। यू ऑल नो सर आइजैक न्यूटन आराम से एप्पल ट्री के नीचे बैठ के पढ़ रहे थे, ऊपर से एप्पल नीचे गिरता है एंड ही डिस्कवर्स ग्रेविटेशनल फोर्स। और सर आइजैक न्यूटन को हमने फॉर द डिस्कवरी ऑफ ग्रेविटी कोई पेटेंट नहीं दिया है। So what is the difference over here, friends? कि discoveries are knowledge which are pre-existing. कभी कोई डिस्कवर वो कर्टन जो है उठाता है, वो नॉलेज बाकी वर्ल्ड के साथ शेयर करता है, so that is discovery. And for please go back. And for discovery there is no patent. So please go back. Back. हम पेटेंट्स की ही बात कर रहे हैं। हाँ, थैंक यू। यानी फॉर पेटेंट डिस्कवरी देयर इज नो पेटेंट, बट फॉर इन्वेंशंस जैसे अलेक्जेंडर ग्राहम बेल को मिला है हम पेटेंट देते हैं। अभी थोड़ी हम हिस्ट्री की बात कर रहे हैं फ्रेंड, कि आपको किसी को पता है कि पेटेंट्स कॉन्सेप्ट ऑफ पेटेंट्स कौन सी कंट्री से ये कंसेप्ट हम आइडेंटिफाई कर रहे हैं, हिस्टोरिकली उसके लिए क्या मान्यता है, फॉर्मली कब पेटेंट्स ग्रांट किए गए, किसी को पता है? एनीवन ऑफ यू? मैं यहाँ 2 बातें शेयर करूंगी, पहले जो एक बिलीफ है वो और फिर एक फॉर्मल रिकॉग्निशन, दोनों की बात यहाँ करूंगी फ्रेंड्स। जब हम हिस्ट्री की बात करते हैं तो आप सबको पता है कि रोमन्स आर वॉरियर्स। रोमन्स एक दूसरे पे हमला भी करते थे। कोई एक वॉरियर रोमन का वो विक्टोरियस भी होता था एंड दे हैव पायोनियर्ड मेनी गवर्निंग प्रिंसिपल्स थ्रू आउट द वर्ल्ड ऑल्सो, पर उन सब में हम अभी एंटर नहीं होते हैं। एक जो रोमन वॉरियर था वो जब भी जीत के आते थे तो बहुत लेविश पार्टीज ऑर्गेनाइज करते थे। और उनका एक शेफ था, उनकी एक सिग्नेचर डिश थी, तो बाकी सब वो डिश बहुत relish करके खाते थे। So what they decided कि जब भी वो पार्टी हो वो शेफ वो डिश जरूर बनाएंगे। सो प्लीज गो बैक टू पेटेंट्स, हम कॉपीराइट का डिस्कशन नहीं कर रहे हैं, हम पेटेंट्स का है डिस्कशन। फाइन, थैंक यू। वो डिश वो जरूर बनाएंगे। अभी वो डिश सब में इतना फेवरेट होने लगा कि दूसरे वॉरियर्स भी अपने शेफ से वो डिश बनवाने लगे। अभी जो ओरिजिनल शेफ था वो अपने वॉरियर, रोमन वॉरियर के पास जाता है और रिक्वेस्ट करता है कि ये तो मेरा सिग्नेचर डिश है, बाकी सब कैसे कॉपी करके बना सकते हैं, कुछ ऐसा एडिक्ट दीजिए कि सिर्फ मैं ही वो डिश बना सकूं। और रोमन वॉरियर, ही वाज ऑन अ वेरी सीनियर पोजीशन, ही ग्रेव एन एडिक्ट कि ये डिश सिर्फ मेरा ही शेफ बनाएंगे, एंड इट वाज फॉलोड बाय एवरीवन एल्स इन दैट रीजन आल्सो। सो हम ऐसा यहाँ शायद अनुमान लगा सकते हैं कि कंसेप्ट ऑफ पेटेंट, उसका ओरिजिन रोमन किचन से हुआ है। मे बी वी कैन बिलीव, आई डू नॉट हैव एनी फॉर्मल रिकॉर्ड, पर कुछ बुक्स में ऐसा जरूर छपा है। अभी हम इंग्लैंड का अप्रोच की यहाँ फ्रेंड्स बात कर रहे हैं। तो इंग्लैंड में इन्वेंशन के लिए लेटर्स पेटेंट इश्यू होते थे। व्हाट डू यू मीन बाय लेटर्स पेटेंट? कि किसी इन्वेंटर ने कुछ नया इन्वेंशन किया तो वो इन्वेंटर वहां की गवर्नमेंट को अप्लाई करता था और वो गवर्नमेंट उनको एक लेटर विद सील भेजते थे कि यस यू आर द फर्स्ट एंड ट्रू इन्वेंटर ऑफ दिस इन्वेंशन, और इस इन्वेंशन के जो भी कमर्शियल बेनिफिट हैं वो आप ही एंजॉय करेंगे। और वो लेटर्स ऐसे थे फ्रेंड्स कि जिसपे सरकार की मोहर सील रहती थी। वो सील ऐसे लगाई जाती थी कि जब लेटर ओपन करे तो सील टूटती नहीं थी। सो दे वर ओपन लेटर्स, लेटर्स पेटेंट, यानी शायद पेटेंट वर्ड वो इंग्लिश जो अरेंजमेंट थी ऑफ ग्रांटिंग लेटर्स फॉर न्यू इन्वेंशंस, ओपन लेटर्स, दैट इज पेटेंट, सो दैट सील डजंट ब्रेक। शायद ये टर्म वहां से हम कैरी आज तक कर रहे हैं। ये बात हो गई हिस्ट्री की। इन्वेंशंस और डिस्कवरी भी हम देख चुके हैं। अभी आगे हम डिस्कशन करते हैं रिलेटेड टू पेटेंटेबल इन्वेंशंस एंड नॉन पेटेंटेबल इन्वेंशंस। आप में से कोई मुझे कह सकता है किस इन्वेंशंस के लिए पेटेंट हमारी पेटेंट ऑफिस देती है? Which inventions are patentable? Any one of you? कोई कह सकता है मुझे? You can unmute, you can interact, you can type. It is your call. ठीक है फ्रेंड्स, वही इन्वेंशंस के लिए हमारी पेटेंट ऑफिस पेटेंट देंगी जो नॉवेल है, मीन्स पहले ये इन्वेंशन नहीं हुआ है, समथिंग न्यू। उसके बाद हम यूटिलिटी की बात करते हैं। सो आफ्टर नॉवेल्टी यू टॉक अबाउट यूटिलिटी आल्सो। आपका फ्रिवोलस इन्वेंशन के लिए आपको कोई पेटेंट मिलता नहीं है। यूटिलिटी शुड नॉट बी फ्रिवोलस आल्सो। At the same time, you should have industrial application. आपने जो कुछ भी इन्वेंट किया वो इंडस्ट्री में बना सकते हो ऐसा होना चाहिए, हैंडमेड, मशीन मेड, वॉट एवर इट इज, बट यूटिलिटी तो होनी ही चाहिए। और द थर्ड क्राइटेरिया फॉर एन इन्वेंशन टू बी पेटेंटेबल इज इट्स नॉन ऑब्वियसनेस। आपने जो कोई भी इन्वेंशन किया है वो पहले से लोगों को पता नहीं होना चाहिए। इट शुड नॉट बी वेरी ऑब्वियस, इट शुड बी नॉन ऑब्वियस। जो इन्वेंशन नॉन ऑब्वियस है उसके लिए ही पेटेंट मिलेगा। अगर उस डिसिप्लिन के सब्जेक्ट को वो इन्वेंशन के बारे में पहले से पता हो तो आपको इन्वेंशन के लिए पेटेंट नहीं मिलेगा। So these are the three criteria for an invention to be patentable: utility, novelty and non-obviousness. उसके बाद हम फ्रेंड्स बात कर रहे हैं the non-patentable inventions. Can any one of you tell me कि कौन से inventions के लिए पेटेंट नहीं मिलेगा? Any one of you? No one. देखिए, yes, someone has written something. What? Fine. You're very right. Friends, non-patentable inventions के provisions, Section 3 Patents Act 1970 में है. आपने कुछ import किया, right? और वो प्रोडक्ट पे आपने यहाँ तो काम किया ही नहीं है. किसी और का टैलेंट, किसी और का नॉलेज, किसी और का स्किल, किसी और ने एनर्जी और टाइम दिया, किसी और ने उसका रिसर्च का एक्सपेंडिचर बेयर किया और आपने कहीं से इनपुट कर दिया वो, और उसके लिए अभी पेटेंट प्रोटेक्शन मांग रहे हो तो नहीं मिलेगा. सो इफ यू आर नॉट वर्कड ऑन द इन्वेंशन एंड इंपोर्टेड इट फ्रॉम सम अदर कंट्री, विल नॉट गेट अ पेटेंट फॉर इट. उसके लिए सैमसंग गैलेक्सी का बहुत ही रेप्यूटेड केस है और यू कैन रेफर, वो जजमेंट एक हाई कोर्ट ने दिया है, यू कैन रेफर दैट जजमेंट. दूसरी बात फ्रेंड्स, जब आप बात कर रहे हो कि सपोजिंग एक एब्स्ट्रैक्ट थ्योरी आपने दी है तो उसके लिए भी पेटेंट नहीं मिलता. आई शुड हैव सम इंडस्ट्रियल एप्लीकेशन. एट द सेम टाइम आपका इन्वेंशन फ्रिवोलस है, उसका कोई यूटिलिटी नहीं है, कोई इंडस्ट्रियल एप्लीकेशन नहीं है, सिर्फ इन्वेंट करने के लिए आपने कुछ टाइम पास करने के लिए कर दिया. फ्रिवोलस इन्वेंशंस आर नॉट पेटेंटेबल. दूसरी बात, आपका जो इन्वेंशन है which is harmful to human life, excuse me, ह्यूमन बींग्स को वो हार्मफुल है तो पेटेंट ग्रांट नहीं करने में आएगा. एनिमल लाइफ को हार्मफुल है, पेटेंट ग्रांट करने में नहीं आएगा. प्लांट लाइफ को हार्मफुल है, पेटेंट ग्रांट करने में नहीं आएगा. सो इफ योर इन्वेंशन इज हार्मफुल टू ह्यूमन बींग्स, एनिमल्स और प्लांट्स, पेटेंट ग्रांट करने में नहीं आएगा. आगे बात करते हैं admixture. What do you friends mean by admixture? Supposing two chemicals are available, आप दोनों ने मिक्स कर दिया और पेटेंट क्लेम कर रहा है, उसमें आपकी स्किल टैलेंट है कहाँ? They were pre-existing. A plus B is equal to C will not get a patent. Now my one gentle question to all of you is, okay, will you be granted a patent for any invention related to traditional knowledge? जब हम परंपरागत ज्ञान की बात कर रहे हैं, ट्रेडिशनल नॉलेज की बात कर रहे हैं, उसके रिलेटेड क्या हमें पेटेंट मिलेगा? यस और नो? एनीवन ऑफ यू? नो. वसंत राव जी इज वेरी राइट. ट्रेडिशनल नॉलेज रिलेटेड कोई भी इन्वेंशन हो, दे आर नॉट पेटेंटेबल. उसका जो फिलॉसफी है कि व्हाई ट्रेडिशनल नॉलेज इज नॉट पेटेंटेबल, हम बाद में दूसरी स्लाइड में डिटेल में लेते हैं. एट द सेम टाइम, सपोजिंग कोई मेडिकल फील्ड से है, उसने एक न्यू लाइन ऑफ ट्रीटमेंट आइडेंटिफाई की है, अपना दिमाग लगा के न्यू लाइन ऑफ ट्रीटमेंट इवॉल्व की है, क्या उनको वो लाइन ऑफ ट्रीटमेंट के लिए पेटेंट मिलेगा? यस और नो? इट कुड बी अ न्यू मेथड ऑफ डूइंग अ सर्जरी, इट कुड बी अ न्यू डायग्नोस्टिक ट्रीटमेंट मेथड, इट कुड बी अ न्यू प्रोसीजर. क्या उसके लिए पेटेंट मिलेगा? अनिल जी इज वेरी राइट, नहीं मिलेगा. उसका रीजन ये है कि अगर पूरी दुनिया में किसी को भी वो ट्रीटमेंट की जरूरत पड़ी तो सिर्फ उसी डॉक्टर के पास उनको जाना पड़ेगा, तो ही वो ठीक हो पाएंगे. तो यू कैन नॉट मोनोपोलाइज लाइफ सेविंग ट्रीटमेंट्स लाइक दैट. तो उनको पेटेंट नहीं मिलेगा. बट वो न्यू लाइन ऑफ ट्रीटमेंट जब आप इवॉल्व कर रहे हो या आइडेंटिफाई कर रहे हो, और वो ट्रीटमेंट के लिए कोई एक अपरेटस, कोई एक दवाई, कोई एक इंस्ट्रूमेंट वो नया चाहिए, और वो कैसे भी करके वो आइडेंटिफाई करते हैं, इन्वेंट करते हैं, तो दैट ट्रीटमेंट के लिए की मेडिसिन, इंस्ट्रूमेंट, apparatus is patentable because वो कहीं पर मैन्युफैक्चर हो सकता है, कहीं भी हम भेज सकते हैं उसको. but the line of treatment as such is not patentable. अभी पेटेंटेबल इन्वेंशंस और नॉन पेटेंटेबल इन्वेंशंस पे हमने बहुत डिस्कस कर लिया. बिफोर वी मूव फॉरवर्ड एक एक्सेप्शन की बात कर लेते हैं. Animal life and plant life per se is not patentable, but microorganisms are patentable. उतना याद रखना. लोग उसके रिलेटेड बहुत सारे केसेस भी अगर टाइम परमिट्स हम डिस्कस करेंगे. बिफोर वी मूव फॉरवर्ड, आप में से कोई मुझे कह सकते हैं व्हाट इज द पर्पस, व्हाट इज द रैशनल बिहाइंड ग्रांटिंग अ पेटेंट? क्यों हमारी कंट्रोलर जनरल ऑफ ट्रेडमार्क्स, पेटेंट्स, ट्रेडमार्क, geographical indications, copyright, industrial designs, वो क्यों patents grant करते हैं? What is the logic behind it? What is the purpose for granting a patent to the true and the first inventor? Any one of you can add to it? You're very right, sir. सेक्शन 3 के अंदर 3D भी है, 3J भी है, 3K भी है, पर वो हम डिटेल में बाद में लेंगे वसंत जी. अभी मैं पर्पस ऑफ ग्रांटिंग अ पेटेंट की बात कर रही हूँ. व्हाट्स द रैशनल? ठीक है, आप लोग कुछ ऐड करें, तब तक मैं ही आगे बढ़ जाती हूँ. कि फ्रेंड्स, एक तो हम कुछ इन्वेंट कर रहे हैं, एट द सेम टाइम हमारा टैलेंट वहाँ यूज हुआ है, हमारा स्किल यूज हुआ है. We have spent money at times, energy, कितने फैक्टर्स हैं. वो सब जब हम लोग इन्वेस्ट कर रहे हैं, टाइम, मनी, एनर्जी, टैलेंट, स्किल, तो डेफिनेटली हमने कुछ इन्वेंट किया है. उसके लिए गवर्नमेंट उस ट्रू एंड फर्स्ट इन्वेंटर को एनकरेज करेंगे, डेफिनेटली करेंगे. एट द सेम टाइम फ्रेंड्स, when a person in India is inventing something new which is having utility and which is non-obvious, then that person is discharging his fundamental duty also. आप में से कोई मुझे इन्वेंशन के लिए हमारा कौन सा फंडामेंटल ड्यूटी है बता सकते हो? एनीवन ऑफ यू? कॉन्स्टिट्यूशन के कौन से पार्ट में है, कौन से आर्टिकल में है? फंडामेंटल ड्यूटी की बात कर रही हूँ यहाँ पे मैं. Our fundamental duties are in Part 4A of Indian Constitution, Article 51A, and हर एक इंडियन सिटीजन की एक फंडामेंटल ड्यूटी है टू डेवलप साइंटिफिक स्किल एंड टेम्पर. सो जो इन्वेंटर कुछ इन्वेंट कर रहा है वो अपनी फंडामेंटल ड्यूटी भी डिस्चार्ज कर रहा है. तो डेफिनेटली उस इन्वेंटर को एनकरेज, यस यू आर वेरी राइट सर, उस इन्वेंटर को एनकरेज करने के लिए हम उनको डेफिनेटली पेटेंट देंगे. प्लस जब तक एवरीवन 51 एक सब बराबर लिख रहे हैं, कॉन्स्टिट्यूशन में सब प्रो है. वेरी नाइस. फ्रेंड्स, आगे बात करें कि पेटेंट का पर्पस क्या है. कि जिस किसी ने भी इन्वेंशन किया है उसने अपनी फंडामेंटल ड्यूटी डिस्चार्ज की है, उसको हम एनकरेज भी कर रहे हैं फॉर हिज इन्वेंशन. एट द सेम टाइम we should monetarily encourage him also. अप्लाई किया था और उसकी एप्लीकेशन से 20 साल तक अगर उसको पेटेंट ग्रांट होता है तो उस इन्वेंशन का जो भी प्रॉफिट है, कमर्शियल बेनिफिट है, सिर्फ वही इन्वेंटर को मिलना चाहिए. इफ फाइनेंशियल एस्पेक्ट इज नॉट टेकन केयर ऑफ तो लोग शायद इतने पैशनेटली, इतने एंथुजियास्टिकली इन्वेंशन नहीं करेंगे. अभी आप बोलोगे इन्वेंशन के नए की जरूरत क्या है? भाई जरूरत है. जैसे जैसे इन्वेंशन होंगे उनका इंडस्ट्रियल एप्लीकेशन होगा तो ही पेटेंट मिलेगा. और जहां इंडस्ट्रियल एप्लीकेशन है, इंडस्ट्रीज नई नई एस्टैब्लिश हो रही हैं, वहां इकोनॉमिक ग्रोथ, इकोनॉमिक टर्नओवर अपने आप देखने को मिलता है. और जहां इकोनॉमिक ग्रोथ पॉजिटिव है वहाँ स्टैंडर्ड ऑफ लिविंग अपने आप इम्प्रूव होता है. दूसरी बात, इन्वेंशन ब्रीड्स इन्वेंशन, दैट इज वेरी इंपॉर्टेंट। अभी हमने अलेक्जेंडर ग्राहम बेल की बात की, ही इन्वेंटेड टेलीफोन, और आज हम सब मोबाइल नेटवर्क, मोबाइल कनेक्टिविटी से कितने फेमिलियर हैं। अगर अलेक्जेंडर ग्राहम बेल ने टेलीफोन का पेटेंट नहीं लिया होता तो वन इन्वेंशन विल नॉट ब्रीड अनदर इन्वेंशन। कहीं भी कभी भी बात कर सकते हैं। सो वन इन्वेंशन ब्रीड्स अनदर इन्वेंशन, इसीलिए भी ट्रू एंड फर्स्ट इन्वेंटर को हमें डेफिनेटली एनकरेज करना चाहिए। आगे हम बात करते हैं, पर्पस में बहुत सारे पर्पस है, बिकॉज देयर प्रॉपर्टी राइट्स, देयर हेरिडिटरी राइट्स, दे शुड बी प्रोटेक्टेड, पर इतना डिटेल में तो अभी मैं नहीं लूंगी बिकॉज दूसरे सेशन में इस पे डिटेल में डिस्कशन होने वाला है। When we talk about term of patent, आप में से कोई मुझे बताएंगे कि पहला टर्म कितना था, आज कितना है, and what is the purpose of increasing the term of patent, और क्यों increase किया, what is the rationale behind it? Any one of you? आप सब तो ऐसे बिहेव कर रहे हैं कि सिर्फ 3-4 जने इंटेलेक्चुअल प्रॉपर्टी राइट्स का सब्जेक्ट पढ़ रहे हैं, बाकी लोग नहीं पढ़ रहे हैं। या मेरे से इंटरेक्शन करने में थोड़ा आपको संकोच हो रहा है, दो चीजें होती हैं। विजय जी, तारीफ के लिए बहुत ही शुक्रिया। एनीथिंग एल्स? नहीं, आई डोंट नो, आई एम बेसिकली अ टीचर फ्रेंड्स, तो मेरा क्या है ना, क्लास में भी मैं बातें करते ही अनिल जी, नाइस गैस, इसको मैं थोड़ा एलॉबरेट करूंगी। बेसिकली आई एम अ टीचर एंड दो आई एम एन एडमिनिस्ट्रेटर, डेली आई गो टू अ क्लास, या मास्टर्स की या बैचलर्स की या मेरी कॉलेज में या ऐसे ऑनलाइन मोड कहीं भी, आई टेक अ क्लास डेली, आई सी टू इट कि मेरा एकेडमिक एक्टिविटी कुछ ना कुछ रहता है। तो लास्ट मिनट पे डिसाइड हुआ तो 2-3 एकेडमिक एक्टिविटी आज के मेरे हो गए। एंड आई ऑलवेज इंटरेक्ट विद द लिसनर्स, माय को-लर्नर्स, तो ही लाइक आई एम कंफर्टेबल। एनीवे, सबका अलग अप्रोच रहता है। फ्रेंड्स, जब हम टर्म ऑफ पेटेंट की बात कर रहे हैं, yes, you all are very right, 20 years from the filing date. तो पर मेरा क्वेश्चन ये था कि पहले कितना था और अब कितना है। तो पहले 14 years था, फिर we all are signatory to TRIPS, और अभी 20 years है। 20 years from date of filing the patent. आपने अप्लाई किया और पेटेंट ऑफिस will take 2 years, 3 years to grant you a patent. अप्लाई किया उस दिन से 20 साल तक आपको पेटेंट, अगर पेटेंट ग्रांट होता है तो मिलता है, और उसका कमर्शियल बेनिफिट आपकी कंसेंट के अलावा और कोई नहीं ले सकता है। अभी दूसरी बात यहाँ हम टर्म ऑफ पेटेंट की करें कि पहले 14 क्यों था, व्हाट वाज द लॉजिक बिहाइंड इट। तो फ्रेंड्स, इंग्लैंड में ऐसा था कि कोई अप्रेंटिस हो, ट्रेनी हो, इंटर्न हो, तो उसका जो इंटर्नशिप है, अप्रेंटिसशिप है, वो 7 साल का था, और जब वो उसकी इंटर्नशिप, अप्रेंटिसशिप खत्म होती है, तो जो भी उनको ट्रेन करते थे उनसे एक अंडरस्टैंडिंग रहती थी कि 2 टर्म्स ऑफ इंटर्नशिप एंड 2 टर्म्स ऑफ अप्रेंटिसशिप के लिए वो लोग वो नॉलेज यूज नहीं कर पाएंगे, वरना जो उनको सिखाते हैं उनके जो भी क्लाइंटल है वहां शिफ्ट हो जाएंगे। सो 1 टर्म वाज अराउंड 7 years एंड 2 टर्म्स वाज अराउंड 14 years। सो ये जो 14 साल का कंसेप्ट है, वहां से हमने कैरी फॉरवर्ड किया था। पर नाउ वी ऑल आर ट्रिप सिग्नेटरी, एंड ट्रिप्स मिनिमम यूनिफॉर्म स्टैंडर्ड्स एक्सपेक्ट करता है सभी मेंबरशिप कंट्रीज के लिए, यानी हम 14 years तक फ्रॉम डेट ऑफ फाइलिंग द पेटेंट, अगर आपका एलिजिबल है तो देते हैं पेटेंट। टर्म ऑफ पेटेंट की बात हो गई, और यहाँ ही हम एवरग्रीनिंग ऑफ पेटेंट्स की बात करेंगे। With pharmaceuticals, do we allow duplication of patents, addition of patents, evergreening of patents? Any one of you? सिंपल मैं कैसे ये इसकी बात करूंगी कि सपोजिंग एक फार्मास्यूटिकल कंपनी है, उसने एक दवाई इन्वेंट करवाई है R&D के थ्रू, और उनको उसका पेटेंट भी मिल गया, जैसे नोवार्टिस एजी को मिला था एंटी ब्लड कैंसर ड्रग के लिए। फिर जब वो टर्म खत्म होने आता है 20 साल, तो फार्मास्यूटिकल कंपनी को थोड़ी चिंता रहती है कि टर्म खत्म हो जाएगा, फिर anyone in the society will be able to manufacture this medicine एंड टेक एडवांटेज, मॉनेटरी एडवांटेज, हमारा प्रॉफिट कम हो जाएगा। तो कुछ फार्मास्यूटिकल कंपनीज क्या करती है ना, केमिकल कंपोजिशन जो होता है उसमें माइनर चेंजेस करती है, माइनर ट्विक्स कर देते हैं और उसके लिए वापस पेटेंट के लिए अप्लाई करते हैं। पर सेक्शन 3 सब क्लॉज डी ऑफ इंडियन पेटेंट एक्ट 1970 एवरग्रीनिंग ऑफ पेटेंट्स को प्रोहिबिट करती हैं एज फार एज फार्मास्यूटिकल्स इज कंसर्न्ड। आपने दवाई में माइनर ट्विक्स केमिकल कंपोजिशन में चेंजेस किए और उस चेंजेस के बाद लाइन ऑफ ट्रीटमेंट में एफिकेसी इम्प्रूवमेंट आता है तो आपको पेटेंट मिलेगा, वरना नहीं मिलेगा। सो ये बात हो गई टर्म ऑफ पेटेंट की। पेटेंट रिलेटेड एक्ट है पेटेंट्स एक्ट 1970। इट हैज बीन अमेंडेड आफ्टर ट्रिप्स 1995 में। वी आर नाउ अ फाउंडिंग मेंबर ऑफ गैट एंड अ डिफॉल्ट मेंबर ऑफ WTO. So TRIPS provisions of minimum standards are applicable to us. और हमने हमारा पेटेंट रेजिम, इंटेलेक्चुअल प्रॉपर्टी राइट्स रेजिम अमेंड किया है, पर वो मैं डिटेल में बाद में बोलती हूँ। राम सर दूसरे स्लाइड के लिए प्लीज शिफ्ट करेंगे। थैंक यू। अब हम कॉपीराइट की बात करेंगे। एनीवन ऑफ यू कैन टेल मी व्हाट डू यू मीन बाय कॉपीराइट? एनीवन ऑफ यू? फ्रेंड्स, मोस्ट पेटेंट सब्जेक्ट टू रिन्यूअल फीस आफ्टर 20 इयर्स के बाद कोई रिन्यूअल नहीं है, इतना याद रखना। बीच बीच में आपको पेटेंट का जो भी पेटेंट ऑफिस है उसके साथ प्रोसेस करना रहता है। अगर आप नहीं प्रोसेस करोगे तो पेटेंट लैप्स भी हो सकता है। बट आफ्टर 20 इयर्स अगर आपने ड्रग्स में माइनर ट्विक्स किए हैं केमिकल कंपोजिशन में एंड बिकॉज ऑफ दैट माइनर ट्विक्स अगर लाइन ऑफ ट्रीटमेंट में एफिकेसी है तो आपको पेटेंट मिलेगा, वरना एवरग्रीनिंग ऑफ पेटेंट्स इज बैंड। और ये जो 2 years है दैट इज within 20 years only, not after 20 years. Okay, now we move to copyright. ये आप पेटेंट के टर्म का डिस्कशन जो फॉरकमिंग सेशन है उनके सब्जेक्ट एक्सपर्ट के साथ आगे कंटिन्यू करना, बिकॉज ही इज गोइंग टू टॉक इन डिटेल। आई मूव टू कॉपीराइट। यस, गणेश जी ने लिखा है लीगल राइट who may print, copy, perform piece of original work, book, song, computer program, very right. See friend, before we move forward, इतना समझ लीजिए कि copyright is available only for expression of your idea and not your idea. Idea per se is not patentable. आपकी आइडिया की जो अभिव्यक्ति है, जो एक्सप्रेशन है, दैट इज पेटेंटेबल। वो आप कैसे समझोगे? आपने वो मूवी देखी होगी रामलीला, आपने वो मूवी देखी होगी काइपोचे, आपने वो मूवी देखी होगी 3 इडियट्स। वो सारी कोई ना कोई बुक पे डिपेंडेंट है, बेस्ड है। एनी वन ऑफ यू कैन टेल मी कि 3 इडियट्स, रामलीला एंड काइपोचे आर बेस्ड ऑन विच बुक्स? वेरी नाइस, कितना अच्छा इंटरेक्ट कर रहे हैं। थोड़ा प्रॉम्प्ट करना पड़ा बस। राम जी, आपके पार्टिसिपेंट बहुत एंथुजियास्टिकली इंटरेक्ट कर रहा है। मस्ट अप्रिशिएट, आई मस्ट अप्रिशिएट। हाँ, आप में से कोई मुझे बताएगा कि 3 Idiots is based on, inspired by which book, by which author? Kaipoche is inspired by which author, which book? And Ram Leela is inspired by which book and which author? Any one of you? चेतन भगत, वेरी राइट। कौन सी बुक चेतन भगत? अनिल जी, कौन सी बुक और कौन सी मूवी की बात करो? हमने 3 बुक्स की बात की और 3 मूवीज की बात की राधर यहाँ पे। जब आप 3 इडियट्स की बात कर रहे हो तो अनिल जी इज वेरी राइट। इट हैज बीन इंस्पायर्ड बाय 5 Point Someone, written by Chetan Bhagat. Yes, Sahebrao ji is very right. 5 Point Someone, उसका एक कंट्रोवर्सी था, वो कभी कोर्ट तक नहीं, मीन्स आगे डिटेल में सेटल नहीं हुआ है कोर्ट में, पर उसका एक कंट्रोवर्सी था, न्यूज़पेपर और ब्लॉग तक ही रहा ज्यादा। तो वो कुछ किसी को पता है related to that controversy? Chetan Bhagat and I think it was राजकुमार हिरानी एंड विदु विनोद चोपड़ा। बीच में आमिर खान जी का भी नाम जोड़ा था पर फिर बाद में ड्रॉप करने में आया। एनीवन, किसी को कंट्रोवर्सी के बारे में पता है? फ्रेंड्स, 3 इडियट्स में हाँ अनिल जी, फाइन। वो 3 इडियट्स में क्या हुआ था ना कि मूवी रिलीज हुई और जो क्रेडिट्स थे वो रोलिंग क्रेडिट्स में चेतन भगत वो लोग एक्नॉलेज करते हैं कि चेतन भगत की बुक है 5.7, उससे थोड़ी बहुत ही मूवी इंस्पायर्ड हुई है। और चेतन भगत मूवी रिलीज होने के बाद ही गोज टू प्रेस, ही राइट्स, ट्वीट किया, ब्लॉग, आई डोंट नो व्हाट ही हैड डन, आई डोंट हैव द ऑफिशियल रिकॉर्ड ऑफ इट, बट ही टोल्ड के मुझे क्रेडिट नहीं मिला। दूसरी बात के मेरी बुक और मूवी में काफी डिफरेंसेस हैं। तीसरी बात, मुझे ड्यूज नहीं मिले फाइनेंशियली। अनुराज कुमार हिरानी वेंट ऑन रिकॉर्ड, ही शेयर्ड द अग्रीमेंट कि चेतन भगत की परमिशन लेके ही हमने मूवी बनाई थी। राजकुमार हिरानी शेयर्स द कॉन्ट्रैक्ट कॉपी ऑल्सो के जो भी ड्यूज थे वो हमने उसको एडवांस में दे दिए थे। चेतन भगत ने क्लेम किया कि आई नेवर न्यू अबाउट द स्क्रिप्ट। तो राजू हिरानी शोज अ ब्लॉग पॉडकास्ट, पता नहीं क्या, ऑनलाइन इंटरव्यू ऑफ चेतन भगत, जहां चेतन भगत एक्नॉलेज कर रहे हैं कि हाँ पूरा स्क्रिप्ट मैंने सुना था। नॉन डिस्क्लोजर अग्रीमेंट भी था कि आप स्क्रिप्ट सुनने के बाद बाहर नहीं कहोगे, एटसेट्रा। What happened we don't know. There was an out of court settlement over here. But what I want to say over here is कि जब ऑथर को अपनी कोई भी बुक के लिए सपोजिंग किसी प्रोड्यूसर ने अग्रीमेंट साइन किया है, उसको फाइनेंशियली कॉम्पेंसेट भी किया है, उसके बावजूद भी मॉरल राइट्स ऑफ द ऑथर सर्वाइव। आपने ऑथर को जो भी पहले से एग्री किया था वो ड्यूज दे दिए, तो आप क्रिएटिव लिबर्टी विद कंसेंट ऑफ ऑथर ले सकते हो, पर वो जो ऑथर का प्लॉट है नॉवेल का उसको कंप्लीटली म्यूटिलेट नहीं कर सकते हो। कुछ चेंजेस लेने हैं तो यू कैन डेफिनेटली टेक द कंसेंट ऑफ द ऑथर बिफोर डूइंग दैट। एक कॉपीराइट की जब भी बात फ्रेंड्स हम कर रहे हैं तो कॉपीराइट आर अ बंडल ऑफ राइट्स, इतना जरूरी याद रखना। देयर आर इकोनॉमिक राइट्स, देयर आर मॉरल राइट्स, देयर आर नेबरिंग राइट्स एंड सो ऑन। अभी ये बात हुई 3 इडियट्स, चेतन भगत एंड 5.7। फिर मैंने बात की रामलीला की। आपको किसी को पता है रामलीला जिसमें क्या दीपिका जी थे और रणवीर जी थे शायद? It is based on and Sanjay Leela Bhansali was involved in the direction of production or something. It is based on which novel, which book, by which author? Anyone of you? विलियम शेक्सपियर्स रोमियो एंड जूलियट। अभी कॉपीराइट का जब हम उसमें भी काफी क्रिएटिव लिबर्टी ली गई थी, बट टर्म ऑफ कॉपीराइट लैप्स हो चुका था, यानी बहुत लीगल कंट्रोवर्सी वहां नहीं है। उसके बाद 3 मिस्टेक्स ऑफ माई लाइफ, चेतन भगत, उनकी और बुक पे से काइपोचे मूवी बनी है। अगर आप में से किसी ने काइपोचे मूवी देखी हो और 3 मिस्टेक्स ऑफ माई लाइफ पढ़ी हो तो दोनों के क्लाइमैक्स एंड में डिफरेंस है, ड्रास्टिक डिफरेंस है। पर यहाँ मेरे पास कोई कंट्रोवर्सी नहीं पहुंची है। उसका मतलब कि जब आप प्लॉट चेंज कर रहे हो तो आपने प्रीवियस कंसेंट ऑफ द ऑथर ली होगी। सो दिस इज अबाउट एक्सप्रेशन। आइडिया किसका, बुक किसकी, उसको एक ऑडियो विजुअल मैनर में एक मूवी के फॉर्म में किसी और ने प्रोड्यूस किया, ऑफ कोर्स विद द कंसेंट ऑफ द ऑथर। अभी moral rights survive even after economic rights have been compensated. Now we talk about term of copyright. Can anyone tell me? Okay, fine. Can anyone tell me what is the term of copyright? आज एक बुक पब्लिश हुई है तो उसका टर्म कितना रहेगा? गणेश इज वेरी राइट। यस, 2 स्टेट्स पे भी मूवी बनी है गणेश जी, पर इतना सब तो मूवीज की बात यहाँ करेंगे तो कहाँ पहुंचेंगे हम लोग। Yes, friends. What is the term of copyright? Lifetime of the author and 60 years commencing from the next calendar year after the death of the author. 60 years is very right, Ahmed ji, but that is lifetime of the author and after the author dies, 60 years commencing from the next calendar year from the death of the author. Supposing lifetime of author गणेश जी पहले लिखिए. Supposing मैं सिर्फ बुक्स और ऑथर्स की बात करें, फोटोग्राफ्स और सबकी अभी बात मैं कर रही हूँ. Supposing author dies today और ऑथर ने बुक 30-40 साल पहले लिखी थी, तो 30-40 साल तो उनको कॉपीराइट मिलेगा ही, उनका कॉपीराइट है ही उस बुक पे. आज मर गए तो नेक्स्ट कैलेंडर ईयर 2027 से उनको अनदर 60 इयर्स के लिए उनका वो बुक है कॉपीराइट प्रोटेक्शन बेयर कर रहा है. सपोजिंग देयर आर 4 ऑथर्स, तो कैसे कॉपीराइट आप काउंट करेंगे? एनीवन? जो भी लास्ट सर्वाइविंग ऑथर है उसके डेथ से नेक्स्ट कैलेंडर ईयर से 60 इयर्स, प्रिज्यूमिंग के सब नेचुरल डेथ मरते हैं और द यंगेस्ट ऑथर माइट सर्वाइव द लॉन्गेस्ट, तो वो उनकी डेथ होके नेक्स्ट कैलेंडर ईयर से 60. आगे हम फ्रेंड्स बात कर रहे हैं इन्फ्रिंजमेंट. अभी मैं डिटेल में नहीं लूंगी बिकॉज टाइम इज रनिंग आउट. रजिस्ट्रेशन ऑफ कॉपीराइट इज नॉट मैंडेटरी बट इट इज बेनिफिशियल टू द author to have his creation registered with the Controller General of Patent. पहले copyright board अलग था, now it is with the Controller General of Trademark, Patent, GI and Designs Office only copyright is existing. जब copyright register में आपका वर्क का एंट्री हो जाता है और कोई आपकी copyrighted वर्क का infringement कर रहे हैं and you go to the court, तो वो एंट्री इन दैट कॉपीराइट रजिस्टर इज prima facie एविडेंस के योर राइट इज एग्जिस्टिंग, स्टैट्यूटरी लीगल राइट इज एग्जिस्टिंग. सर आई थिंक और बहुत सारे स्लाइड्स बाकी है बट वी आर रनिंग आउट ऑफ टाइम. राम सर, शैल आई एंड? बिकॉज इट इज इनडिसिप्लिन, यू नो, आपको अलॉट किया गया स्लॉट, उसके बाद भी बोलते रहो. राम जी, शैल आई स्टॉप?
Yes, ma'am. Yes, ma'am.
ओके, फाइन. और किसी को कुछ इंटरेक्ट करना है 2 मिनट के लिए? स्टिल अभी 1 मिनट है. एनीवन वांट्स टू इंटरेक्ट? आई एम डन, राम सर. द सेशन इज ओवर. इट्स 12 noon.
Okay, madam. Okay, thank you so much, ma'am, for your valuable inputs. Thank you, ma'am. You really made this session interesting to various examples. Thank you for your enlightening session. Madam, you explain various concepts like meaning and history, term of patterns, various concepts like inventions and discovery. You also tell us the difference between invention and discovery in a very simple manner. Also, the meaning of copyright. Also, I would specially like to thank you, madam, for that you accepted our invitation on very short duration. And thank you so much for that. Now, with all your permission, madam, we will now move to our next session because our next resource person have already joined. Thank you very much, ma'am. Thank you very much.
Ram sir, thank you for inviting me and convey my thanks to Sunny Hassani sir.
Okay, madam. Thank you. Thank
I take your
you. I
leave.
will.
Thank
Okay,
you.
madam.
Wonderful audience, all of you. Bye.
Welcome, madam. Welcome. Now, dear participants, as we all know, we are having this excellent session since morning. Now, as we have arrived to the conclusion, now as we have arrived to the final session of this conference, we have with us Dr. Bharat Suryavanshi sir. For his kind introduction, I would like to invite Dr. Bharate sir. Over to Dr. Bharate sir.
Good afternoon to all distinguished guests, respected dignitaries, and dear participants. It is a matter of the great honor and privilege to introduce our esteemed speaker for today's session, Dr. Bharat N. Suryavanshi. Dr. Suryavanshi has been serving for more than 20 years in the central government under the Patent Office, Ministry of Commerce and Industries, Government of India. He is currently working as the Assistant Controller of Patents and Designs, where he plays the significant role in the examination and administration of intellectual property rights in the country. He holds the PhD from Swami Ramananda Tirtha Marathwada University, Nanded, Maharashtra. His doctoral research focused on the bioefficacy and phytochemical studies on medicinal plants of Kinwat and Mahur forest of Nanded district. He also completed his the MPhil from Gulbarga University, Karnataka, and earned his postgraduate degree in biotechnology from the same university. Dr. Suryavanshi sir has published several research papers in national and international journals, and he's delivered the numerical lectures on intellectual property rights across the country. He was deputed to Tokyo, Japan for specialized training in patent examination and IPR issue. He has also participated in various judicial, national and international training programs related to IPR practice. Notable, he is delivered to landmark decision by rejection the patent application filed by Pfizer for an arthritis drugs, demonstrating and his the commitment to fair and rigorous patent examinations with his the vast experience, academic experience, and the deep understanding of intellectual property rights. We are truly privileged to have him with us today. We are very happy to proud to have in this session, sir, and very warm and heartfelt welcome to you, sir. May I now request to Dr. Bharat N. Suryavanshi to kindly address the seminar. Thank you. Thank you so much. Sir, may I request to Dr. Bharat N. Suryavanshi to kindly address the seminar? Suryavanshi, sir, are you here, sir?
1 minute, sir. 1 minute. 1 minute.
Okay, sir. Okay, sir.
Now my slides are visible to you.
Yes, sir.
Yeah. Good afternoon to all. I welcome you all for the IPR session on behalf of Rajiv Gandhi, National Institute of Intellectual Property, Nagpur. Since morning, you are knowing about the inventions, intellectual properties, and copyrights. Now, in addition to that, let us in detail how to convert your idea, how to convert your ideas, what you're getting in your mind, to an invention. For that, we should know what is idea, how we are able to generate that idea, and how you are able to convert your idea into an invention. So let us see in detail what is intellectual property. So I'm trying to make you understand what is intellectual property by taking the first slide of the mind where it is blooming, or we can say lightning. Why? Because any idea if you are writing new book on AI, how you are writing? The idea is getting from your mind. Therefore, you are able to write that book and you can go for the copyright, as ma'am has recently told you about. Or somebody is developing new technology. What is that? For example, today, as March started, so I'm feeling too hot in Vidarbha because I have transferred from Mumbai, so I don't know this much hot. So I'm feeling very hot in Nagpur also. Again, the Marathwada people also feeling too hot in the March. Even Telangana also. This is the basic problem in and around us. We are feeling too hot since the March month has already arrived. So being a common man, being an inventor, being a professor, being a student or anyone else, how my idea is able to give the solution to this technical problem. So you can unmute and you can guide me also, no problem at all. You can unmute yourself, you can guide me. So can anyone tell me what solution you are able to solve this problem by innovative idea or by thinking on your own? Because I'm able to make you understand what is intellectual property. Yes, dear participant. Why? What is the idea you are giving to be feel cool out of this hot environment? For example, I'm holding my umbrella and walking. So I'm feeling somewhat cool. I'm feeling again hot as Nagpur is too hot. So I'm trying to attach small fan to my umbrella. So I'm feeling again cool for that. Is it solution to technical problem? If you're unable to mute, you can put in the chat box. Is it solution to technical problem? Is the idea is innovative or not? Yes, dear participant. Is idea what I'm giving this hot environment is in new or novel? Yes or no? At least you can put in the chat box. Because the solution what I'm giving to this technical problem is not at all inventive, not at all novel. Because umbrella is also known in the public domain since long back. Even fan is also known back since long back. I'm making mere arrangement or rearrangement of a known devices. It's a mere जुगाड़. In Marathi we can say हे आपण जुगाड़ बनवतो. ये हम जुगाड़ बना रहे. It's not an innovative idea. It's not a solution to technical problem. Then what could be the solution for this? One of the engineering college from Andhra Pradesh has filed cooling cap. It's an innovative idea. It's not a mere jugaad. So problem came, you are giving solution for that. Again, a technology, innovative idea. So the solution is getting from your mind. Therefore, I can say the product of mind is called intellectual property. The product of mind is called intellectual property. I'll quote another example to make you understand. In December 2019, we heard about the coronavirus. At the time, no one was knowing what is coronavirus. कहाँ से आया पता नहीं, China से आया. Nobody is not knowing. Even doctors were not knowing what treatment are supposed to be given. So scientists all over the world started to carry out the research. And in the middle of 2020, we got Covaxin, Covishield, and Sputnik. What is that? Problem came. Scientists thought they have given solution to technical problem as an vaccine composition. So again, innovative idea. As I am from the zoology department, there are many problems in the pond for aquatic life. Water got polluted. So government comes to know they are throwing some chemicals to clean the pond water, or we can say lake water. We know that chemical is affecting the aquatic life, food chain, food web, we all know, no need to say in detail. So you are being a zoology fellow, being a science fellow, what could be the solution you are giving? What idea is coming in your mind to solve that problem? Anyone? So somebody is developing herbal method for treatment of pond or river. What is this? Solution, alternative, chemical is there, but I'm giving alternative solution technical problem. Again, innovative idea that is arising from your mind. This is called as an intellectual property. You can go for the patent. I'm in lecture. Will you call me after 1 hour? Okay. So always think why I'm showing this Dimag ki batti jalao. I have taken this first slide to make you understand, because we never questions ourselves why. Why there is chemical treatment? Why can't I give herbal treatment for that? So this is an innovative idea to solve the problem. You can go for the patent. Now I'll quote another example to make you understand. I'll take simple common example. You are being professors, students or highly educated fellows are using different kind of shampoos to take your head bath. So you can chat in the chat box what kind of shampoo you are taking to take your head bath. Maybe somebody using Vatika, Sunslick, Doe, Wow, Mamaearth, Vedic shampoo. Many are. Why? Being a science and technology fellow or common fellow. Somebody is giving advertisement hero heroines. Or you know the content of that? Or you know the efficacy? But no, we don't know. Simply somebody is using, I'm using that. I am a fellow of botany working on the medicinal chemistry or medicinal plants. So I'm developing improved herbal shampoo composition for treatment of dandruff. If I'm able to show good result than Vatika, Vedic shampoo or any other kind of herbal shampoo, I can get patent for that. But to show how I am different from them, what is the efficacy, composition and clinical trials of that. Then the idea is to give the improved shampoo is arising from your mind. Therefore, we can say it's an intellectual property. It's an innovative idea. You are giving solution to technical problem. That's called intellectual property. Is an nothing but product of your mind. That's called intellectual property. Is clear? Yes, dear participant. What is IP? Clear? Can I proceed? Okay. So let us see how this property arises. ये सब idea मेरे मन में कैसे आती है? जब मैं अकेले बैठूंगा, I'm sitting alone, thinking on different problem, I may get solution to technical problem, or I'm the staff room discussing on a particular problem, or I'm the research laboratory doing the research on a particular topic, or in the classroom I'm with the professor and students, I may get solution to that. Therefore, the property that arises from human mind or product of human creation is called an intellectual property. For example, at present, there are many processes for production of beverages from the food grains, plants, many products are there. But I'm getting less purity, less yield. So I'm from chemistry or chemical engineering background. I'm developing improved process of production of beverages from the grapes or any other food products. In that, if my process new, improved, and I'm able to get more result, then I can get the patent for that. For example, in the year 1950s, we know how to produce the alcohol from sugar molasses. But at that time, the process were very crude. Fermenter, what you are used to fermentation, that machines were very crude. But now, somebody from mechanical engineering and chemical engineering, together, he is developing fermenter, he is developing process of production of alcohol from sugar molasses. For 1 quintal of sugar molasses, I used to get the yield just 10 to 20 liters of raw alcohol earlier. Now, because of my improved process and fermenter, I'm getting 30 to 40 liters of raw alcohol or 60 liters of raw alcohol. What is that? Improved process of production of beverages, I can get the patent for that. Because I'm showing more improvement, more purity, then the idea is arising from your mind. Therefore, it's an intellectual property. पहले एक्सरे मशीन था, डॉक्टर कहते थे you are having some infection and they used to give the antibiotic to you. But now you have got improved medical device as a CT scan machine where doctor can say you are in 5 score of infection, 6 score of infection. What is this? Improved result you are able to show because of improved medical device. So you can get patent for that. That's again innovative idea and technology. So simply you can say any idea that arises from your mind is called intellectual property. For example, smart shoes. बाटा कितने सालों से है, Piba, Adidas. No one thought to solve this problem. This is a basic problem for the blind people. But no one is thinking. One of the Austrian company thought of bringing the smart shoes for the blind people. What is this? Innovative idea. You know, blind people are walking very slowly with the stick. Every step they have to put the stick again in front of them. and they have to work. It takes time-consuming process. To solve this problem, one of the Austrian companies made use of ultrasonic sensor, wherein the blind people can detect the obstacle up to 4 meters away. What is this? Invention of technology. But very crude, बहुत पीछे है. So one of the EVS people has developed a smart cane for the blind people. What is this now? And why it is needed now? Already this is in prior public domain. Many are using, but very crude technology. What smart cane says? It can detect how much water in front of you. Many blind, even village, city, you know, our roads are always having some problems. So how much water on the road they can detect. So blind people can decide whether you have to walk or not. How much mud on the way, whether signal is green, we can walk. With the red, it indicates that much we improvement in the technology we got. What is this? Invention, idea, solution to technical problem. Again, innovative idea arise from your mind. Is an example of invention or technology. मोवाचे फुलं, मोवाके फूल म्हणले की डोक्यात येतं की दारू बनवतात. It's true. In the prior public domain, we know it's went for only production of the liquor, but one of the professor from your Nagpur, Bal Pandey College of Pharmacy has developed cold drinks out of that. And surprisingly, people like the taste of that. What is this? Invention or technology? It's called Mova drink. Again, great formulation. So solution has brought, which is new, novel, and is very much useful to our health. That's again cold drinks, we can say. So these are the simple inventions. Let us see what is the background of intellectual property. प्रॉपर्टी कहते आपके मन में आ जाता मेरे पास घर है, गाड़ी है, बंगलो, अरे गावाकडे शेती पण आहे, so I'm very rich enough. But there is another kind of intellectual property. Maybe other speaker have dealt with you. That's creations of your mind. That's called intellectual property. In that we are having these kind of properties like patent, designs, trademark, copyright, trade secret, and plant varieties. Now let us see one by one. I have given the thing IP means product of mind, but how to define? You might have seen the movie Three Idiots. In that, the method of giving shock, something new idea. And that hero is having more than 127 patents on his name. And he has defined what is machine. Same way, if you want to define IP, intangible, creations of whom? Human intellect. You are creating that. You are the intelligent animal in the alien kingdom. Having power of thinking, therefore, you are taking lot of challenges. You went to Chandrayana. You have invented aeroplane. What not you are doing? Because you are thinking, you are able to solve. So definition is intangible creations of human intellect, having commercial value, asset like any other form of property. If you are saying plot at Chandrapur, you are selling, you are getting money out of that. Flat at Nagpur, you are selling, you are getting the money. Gold, you are selling, get the money. What about your intellectuals? For example, if I am developing the process of production of biodiesel to tackle the problem of petrol and diesel, अभी ईरान का युद्ध चल रहा है. So we cannot get the petrol after that. It's not an enable source of energy. So somebody among you, any common man, is trying to develop biodiesel, the process of production of biodiesel. What is this new idea? Intellectual property. You can get the money out of that. Once you're developing formula, any company like Reliance, HP can approach to you for licensing and you're getting money out of that. What is this? It's an intellectual property, new solution to technical problem, and it has a commercial value. IP is called as an exclusive right. For example, from your college, somebody is filing patent. The right is with that person, not with the spouse, children, or parent. Only he can exercise the power of that. Therefore, we can say IP is a negative right because other person in the family cannot exercise the power of that. Therefore, we can say it's a negative right also. Again, IP is also called as an territorial right. What is territorial right? Once you are applying for the patent in the government of India, your right is valid only in the country of India. You cannot claim in USA. Japan, Germany. Then how to claim? Even you can file your application even in the foreign countries also. How? By means of two-way. One is called PCT, Patent Cooperation Treaty. Another is called Convention Application as per section 135 of the Patent Act. So there are two ways to file your application even in the foreign countries, and you can stop them from using your technology or invention. IP is called as an licensable right. Pfizer drugs, vaccines were developed by Pfizer company like Covaxin, Covishield, but they have assigned or licensed the right to Serum Institute of Pune for more production. What is this? It's an licensable right. Now, what is patent? Anyone? You have learned morning inventions and all. What is patent? Anyone can? Exclusive, monopoly privilege or right granted by the government of India or government to the patentee for 20 years from the date of filing or priority for commercial gain. Who is patenteer? The person who is applying for the patent was the applicant at the time of filing, but now he's getting grant for that. So we can call patentee. He's getting patent for 20 years from the date of filing. When you are disclosing everything clearly, then only you are getting the patent for that. For example, I'm a student of veterinary science. I'm developing food composition for poultry. What is my food composition? How it is beneficial to yield the flesh of the chickens? I have to write in detail what is that food composition, nutritive value of that, then you can get the patent for that. Nutritious composition for the children who are suffering from kwashiorkor marasmus. Powder form both are dabbe aate. You can go for that. For example, at present, you know, for the cancer disease, we are having allopathy and chemotherapy. Somebody among you is developing herbal composition comprising so and so medicinal plants with the other experiment for treatment of cancer. At present, there is no herbal medicine for the cancer. So you are the first person to claim that. So you can get the patent for that. Then any companies who are involved in the herbal production, they can approach to you for licensing. You are selling in the market, you are getting money out of that. For that, you have to disclose what medicinal plants you're using from, which locality, whether you are taking NBA permission or not, detailed experimentation, efficacy, data, clinical trials, all you have to give, then you are getting patent for that. That is called fully particularly. If you are not disclosing anything, then you'll get objection from the government of India that your invention or technology is not fully particularly described, hence delay in getting the patent. So starting you write in detail about your patent or project, what you're filing to get the patent for a research work or a project. Now, many science people are doing project, even commerce people are also doing project, even all political science, other branches also doing the project. While choosing your project, you should understand whether your research topic for the PhD, project topic for BSc and MSc, if it is going to the discoveries or you are doing the inventions. Many professors says, बच्चों 3 टॉपिक ले आए मैं एक फाइनल करता हूं for the project or for PhD topic. Is this the way to select the project topic or research topic? No, not at all. You should know what is prior public domain problem in your own field. If you're physics, electrical, mechanical, chemistry, botany, biotech, whatever field you are, what is prior public domain problem? How we are able to solve that? The solution, if it is new, you can go for the patent. If solution is a discovery, then you cannot get the patent for that. So what is discovery? Finding or exploring something which is already there in the nature, and discovery is not patentable at all. It does not have technical effect. For example, rubber, somebody has discovered it, but someone made tires for two-wheeler and four-wheeler. What is this invention? Useful article. As I am student of microbiology, I am taking my project to isolate microorganisms from effluents of Serum Institute of Pune. So I'm going to Serum Institute of Pune, collecting the effluents from that company and taking project to isolate microorganism. The process of isolation of microorganism may be new if I'm changing pH, temperature, or media of isolation. I can get patent for that, but I cannot get the patent for the microorganism which are just isolated because it's a discovery, and discovery is not patentable at all. But inventions are patentable. Then what are invention? When I can say my project topic is qualifying the definition of invention. When I can say my research topic is qualifying the definition. When I can say my research student topic is qualifying the invention or not. So let us see what is invention. Invention means new product or process. Composition comprising so and so content is a product. Like shampoo is a product. Process of making shampoo is a shampoo process. ATM machine is a product. Computer is a product. And medicine is a product. Process of making medicine is a process. So your topic should be product or process. Useful to all. Something novel, नया होना चाहिए. Non-obvious and should not be in the public knowledge before the filing date. आप पेपर पब्लिश करते होंगे. While doing your project paper publication, what you check? You check whether my research article in the public domain in the way of international journal, national, or in either book or in common platform. If not, then only I'll go for the publication. Same way, if you want to get the patent, your topic should be product or process, novel, inventive, and capable of industry application. Again, it should not attract section 3 and 4 of the patent. Section 3 and 4, I cannot go in detail because it contains the list of non-patentable lists like method of treatment, software, method of presentation. We are not giving patent. Please go through section 3 and 4 in detail afterwards. So invention, if you want to qualify your research topic, it should qualify this, then you can go for the patent. So I can say patent is given for the technology only. Simple example are taken to make a paper clip got the patent in the year 19th century and invented by Norway. You may be professor, doctorate, awarded many PhDs under you, but you are not inventor at all until unless you have the patent on your name. So we can say John Waller is an inventor. I cannot see you as an inventor. Why he has invented? It's very difficult to keep the age-old paper without ruining them or poking them. For that, they have given solution. It's an innovative solution. New idea in the year 19th century. Zip. Earlier, we are having buttons to the pant, shirt, all, but now in zip. What is this? Inventive idea. New, and patent is granted for that. These are the simple inventions. Pen. पहले ऋषि मुनि लोग मोर के पंखों को डिप करके लिखते थे. Now, ink pen, ball pen, all these are simple inventions. We take our pet to walk. So we think my house should not get contaminated or polluted. Let on the other side, let on the road. For this also, somebody has invented, brought the technology that is inventive idea. Name is dog waste catcher and holder device. What is this? Invention or technology. So somebody has given solution technical problem. Enhance fish attractiveness. अभी भी हम लोग मच्छी पकड़ते हैं नदी नालों में समुद्र में. So what we are doing? We are spreading net in the pond, river, lake, or ocean. But now somebody has invented enhanced fish attractor device. What is this? Invention or technology. See, we are having mobiles, but at that time there is no front facing camera, no need to take the selfies. Now we are having the patent for which we got the patent for that. Its title is front facing camera and maximize display screen on mobile device. It consists many things and we are able to take the selfies of us. So they got patent. Number is US 10 so and so issued on 2019. So this is the inventive technology or new solution to technical problems also. You know, earlier you used to sign in the attendance system. Now somebody has brought, no need to sign, just put the thumb or blink your eyes. What is this? invention, method and apparatus for authenticating the biometric scanner. So what is this? Solution to technical problem, having software with the hardware. So you can go for the patent. Software as such, you are supposed to go for the patent. Software as such, sorry, you can go for the copyright. Software with the commonest hardware like ATM machine, CT scan machine, and any system, you can go for the patent. So these are simple inventions. See, these all are knowing this telephone. Can anyone tell me this device was in the public domain since 1876? When British were ruling our country, 1850s, they used to talk by using these telephones even in the foreign countries, even though someone thought to bring the mobile phone. What was necessary? Why they thought to bring the mobile phone? Yes, you can put in the chat box messages, or you can just tell me, or you can guide me why someone thought to bring the mobile phone. If phone था, हम मराठी मूवी हिंदी में देखे होंगे, इसके जरिए भी हम बात करते थे, इवन दो किसी ने मोबाइल लाया, क्यों? वाई? ऑलवेज आप फिजिक्स के हो, केमिस्ट्री के, मैकेनिकल, किसी फील्ड के हो, वाई ये आपके मन में आना, एक क्यों? हर एक रिसर्च करते टाइम प्रोजेक्ट तन आप कुछ कर पाओगे. There are some disadvantages with this telephone, wherein I cannot change this telephone from my cabin to my principal sir cabin, or I cannot change from my cabin to my professor's cabin because it is connected in my cabin. So everyone has to come to my cabin to talk. Again, if you want to dial 10 times, you have dialed very hectic and time consuming. To solve this problem, somebody brought the table phone wherein I can dial easily 989293 like this, but I cannot change again from my cabin to someone else's cabin. Therefore, we got cordless phone. We can take in the hall, kitchen, drawing room, but I cannot take in the meeting, nor in the car, nor in the plane. To solve this problem, we got the mobile phone in India in the year 2002 or in that. Only incoming, outgoing, there is no video calling facility. There is no Google Meet, Zoom Meet, or WebEx Meets. So we got video calling facility, Google Meet, Zoom Meet, WebEx. What is this? Improvement of technology from AG belt to mobile phone. From this example, I want to make you understand that getting patent is not difficult. Even you are improving your technologies, process, product, you can go for the patent. So you learned everything about the patents. So let us see another kind of intellectual property called designs. What are designs? You can check my iron box. You can check my water drinking jug. You can check my watch, spectacle, anything which looks beautiful that may be shape, configuration, pattern, ornament, or composition of lines or color combination thereof applied to any article in the form of 2D, 3D, or both the forms. So you can go for the design registration. Term is 10 years. You can register for again by filing form 3, 5 years, total 15-year terms for the design. Flash design, mobile design, car design, handle design, mere any design are safe if you are applying for the any article by means of industrial process, manual, mechanical, or chemical to separate or combine finished article that judged us only by the eyes. How it looks, that's a design, but does not include any mode of principle of construction, anything which is in substance, mere mechanical device, does not include any trademark or property mark. How it looks, that's a, see, this and car, Ertiga, Mahindra, Tata, Thar, all the designs are different. Mere functional or technical feature of the article is not design. How it looks, that's a design. Term is 10 years. It can be extended for 5 years. Total 15 years term for the design. See, shoes design, chappals, wall, clock, plumbing designs, water bottles, bag, suitcase, briefcase, your ID card, spectacles, shirt design, pant design, all comes with the design. Fan, AC design. In our office, we are having Godrej ACs and Samsung. Somebody have Dell AC, Olo AC. The design is different. Big scale industry washing machine, LG, IFB, both are washing front loading, top loading. So design is different. Mixture design, Bajaj mixture, something different. Vacuum cleaner. So anything which looks beautiful, that's on design. See, beautiful cup set. You can check. Have you seen in any hotels? Spoon set, cooker set, plate set, sofa set, chairs, even set of articles you can go for the registration. Sanitizing machine, it was not there before the corona. Now we are having. Ampoules, capsules, syringes, all the designs are different. See, you can see this capsule, and paracetamol round in nature. You can see this ampoules, syringes, these ampoules, even these ampoules. This is a temperature measuring device. It was not there earlier. Now during corona, we saw this. Textile design, jewelry design, earrings, bangles, watches, all the designs are different. See, design, wallet design, you can check your wallets. Comb, this comb design, other you can check your comb. Water bottles of AquaGuard, Aquafine, Sunrich, all the designs are different. See, again, you can see all these water bottles, but the design is different. See, this all the bottles are there, but all the surface pattern, everything is different from other designs. Therefore, they're in the market and they are value for that. See, this is the sharpener, you know, but dual in nature. You know, pencil, peacock and parrotfish. You know, biscuits, Monaco, Good Day, Parle-G, but this is a new design. This is a pen design. See, all these are different kind of designs. Dress designs. Again, these are the design developed by one of the student of National Staff Design Ahmedabad. Our students are also doing project during the final year of degree or PG. What they might have doing? They might have going to the libraries, copying the sceneries, just changing the data. It's not an innovative work. This fellow is of National Staff Design Ahmedabad. He has done this project to solve the problem of the coolie people who work in the construction company. They are carrying out stones, bricks, sand, cement directly to the head, so they may have neurological disorder, have nerve correction, back pain, this pain. To solve this problem, they are thought to bring such kind of design. It is not in the public now. It somebody has filed the new design. Again, great invention, or we can say technology. Let us see another kind of intellectual property called semiconductor integrated circuitry or design rights. So earlier, we are not having any protection for this. Now we are having this system to protect. If you are able to physics, electrical, electronics, people are knowing what these circuits are actually. If they are original novel layout of designs of semiconductor, integrated circuits, they can go for the protection through the registration in the government of India. Registration is done after the examination if it's new and after publication also. The office is located at Delhi as an SICLDR office, located at the Delhi, and you can file online or offline. It is left to you. Term is 10 years for this SICLDR. Again, we know trademark or brand. If you're developing your own startup, MSME company, or any other shops, whatever may be, you have to keep the mark or logo of that. That's called brand name. Tata, Bata, Parle-G, Good Day, Monaco. What is this? Visual symbols, which may be word, name, brand, numerical or combination of colors to indicate the source of the good, to distinguish from the goods of the other. We know Adidas shoes in the mall, more than 4,000 rupees. If you're going to the Mumbai Bhendi Bazaar or VT side, 200. Why? They're changing spelling or mark of that. Adidas, they're putting B, but we never read a B. We read Adidas because we're habitual of reading Adi only. So we are in confusion and they will be cheating the public. Since how long we are using Pond's powder? Many of people says spelling PONDS, somebody say PONDS, but Exact is POND apostrophe S. So we don't know such kind of simple names of the company or mark. So you'll be cheating the public. Therefore, if you are developing a startup, MSME, any company, please keep the brand name of that, trademark of that, so that no one can copy your mark, or you are the only player in the market. Because Reliance, no one can copy. Reliance Fresh, it's good company. We believe in its name and fame. Apple, we believe it's good company for the mobile and a laptop. It protects the innocent public from buying the goods of second-rate quality product. Or you might have seen with encircling money product like medicines, PCR, RT-PCR, many glasswares, Borosil and all, are with encircling registered trademark. Means that company has already filed the trademark. They got registration after the examination and publication, any operation they overcame, and they got this. TM means you applied for the mark, yet to get permission from the government of India. Once you apply for the mark, it's go for the examination. Then operation may come. All procedure you have to complete. If applicant is able to satisfy all the grounds of opponent, then only you can register that. If not, then you can go for the opposition proceedings. If applicant is able to satisfy all the grounds, then we can register your mark, then you can use R and certificate. Duration is 10 years. It can be renewed every 10 years, subject to issues like Tata, Bata, how long they're in the market. There are different trademarks, collective mark, certification marks, taglines, slogans. Dil Mange More is a kind of trademark. Bureau of Indian Standard is a trademark. So you can go for the mark which you are able to keep for your company. Coca-Cola, Maaza, Sprite, also different kind of trademarks. Trademark registration is not compulsory at all. However, it has some advantage. Therefore, you can go for the national level, even regional level also, for or international level for the protection of that. Initially registered for 10 years, it can be further every 10 years you can go on renewal by paying the renewal fees. As already somebody has dealt with the GI in detail, so I cannot go with the GI also. Even ma'am has told what is copyright and how to file. I'll go for directly for that. The copyright filing is you have to go for the www.copyright.go.in, wherein you can create your login registration ID there, like a train booking, how we are creating that. No need of any signature like digital or e-signature. You have to create your ID and password, log in that. Form 14 will be open. Fill the form 14 if you're having books, novel, story in the PDF form. lecture फोन केली का ठीक आहे मी येतो लंच करून येतो ठीक आहे हो ठीक आहे ओके so and if you want to file the copyright, your document should be in PDF form, and fill the form, upload document, and pay the fees online. 500 per work for the literary dramatic, and pay the fees online. 30 days waiting period for that. Any objection you are getting letter, you have to reply for that. If there is no objection, that will be accepted. Any option you have to reply. No communications, then we think opposition come, then opposition proceeding will be then. If opposition proceedings overcome, that will be go for the registration. See, these are the different type of works. If you are doing, if you're writing books, novel, story, autobiography, poem, thesis, literary work, any kind of literary work, you have to go under section 2 of the Act. If you're doing artistic work under section 2C, drama if you're writing 2H, musical works 2P, sound recordings 2XX, cinematography films 2F. So each kind of work is getting registered in the government of India. You know, we speak, Bahubali is dubbed from Telugu to Hindi. What is the dubbing and all? Somebody is copying without information or without including you or without paying royalty to you. If you're copying without permission, the infringing process will go against you. So please take the proper permission, then use anything if you want to. Even for the benefit purpose, for commercialization, you cannot use even the photos which are there in the Google, drawings which are there in Google, because they are written C with round N circle. We cannot use. For teaching purpose, you can use, but not for the commercialization. There are many case studies for the corporate, like monkey selfie taking photos. So who is the owner of this? So let us see who is the owner of that. For the literary or dramatic work, author who is writing that, he is the owner of that, he is having the right of the copyright. For the musical work, the person who is composing that, which is called, we can say music composer is having the right for that. Artistic work or other than the photograph, the person artist is having that. The photography, the person who is taking the photographs. So your photo is good, then person who has clicked that photo, he's having the right for that. For scenic or film or sound recordings, producer is having that. Literary, dramatic, musical, artistic work, which is to compare computer generated, the person who causes the work to be created is the owner of that. So all about the copyright. The term for the literary, dramatic, musical, artistic work is the life of the author plus 60 years. Therefore, you might think many singers are no more, but still they're getting royalty for that. When downloading songs, we have to pay, option will come. Why? Because of the royalty. For cinematographic films and sound recordings, 60 years from the date of publications, like cinema, Gadar 1, Gadar 2 came, but same producer. If any other coming from the date of application, we have to get the 60 years. Fees is given the website. Please go to the www.copyright.gov.in. You'll come to in detail about the copyright. Let us see another kind of intellectual property called trade secret. Some invention, data, information, if you are unable to get the protection, then you can keep secret, like process of making pizza. We are making the pizza in the home, but we cannot get the same taste as per the Domino's. Why? We don't know what ingredients they are adding. We don't know what the process of making dough also. So therefore it's a trade secret. If you're having any idea, survey method, manufacturing process, etc. Sauji masale. We don't know. When I came to Nagpur, then I heard Shauji. Before that, I was not knowing. Because something special ingredients are there. You can keep secret, I can go for that. Mumbai pav bhaji taste is different from Nagpur pav bhaji. Mysore benne dosa. The benne dosa, we are getting all the hotels in Nagpur also, but the same taste we cannot get because something different. The formula Coca-Cola, Maaza, Sprite, since how long we are drinking, till today we don't know. Why? They're maintaining as a trade secret because no one can copy and they're continuous, they are in the same field, they are manufacturing. The persons who are working in that company, they are doing the non-disclosure agreement. Therefore, they can keep in trade secret. मी लेक्चर मध्ये आहे 1 वाजता संपत आहे. ठीक आहे, 1 वाजता लेक्चर मध्ये आहे, 1 वाजता संपेल. ठीक आहे, ये so we'll take one example to make you understand. Even plant varieties, Jaya, Pusa, Padma, Basmati rice, Kala Mash, all these varieties are coming. How to protect the seed varieties? These all comes under the IPR, but not under the Patent Design Trademark Act 99. It is dealt separately under the Protection of Plant Varieties and Farmers' Right Act 2001. If you are able to bring new and novel varieties, which are distinct, uniform, stable, you can go for the registration. Term is for annual crops, 15 years, for trees, 18 years. Now, who can file this? Where we can file? The breeders can file, farmers, university, even agriculture institute also go for the registration of these seeds. We are getting genetically modified seeds, genetically modified plants, many rice varieties, many food grain varieties. Who is bringing? The persons who are involved in the research, so they can file for new varieties under the Protection of Plant Varieties Farmers' Right Act, and they get protection for their varieties. So you learned all about the intellectual property, especially the idea which is arising from your mind to the how to create and product or process, how it can bring inventive. All you learned about the intellectual property rights. Now let us see how to file the patent application. Who can file? So this is our website to make you understand. For example, you want to file the patent application. So if you want to know more details, you have to click here about that. If you want to file the patent application, comprehensive e-filing column is there. For e-filing, if you click on that, patent design trademark will open. If you want to file the patent, click on that and you should have e-signature or digital for patent filing. If you're filing trademark, digital signature required. For again, if you want filing design, digital signature. So for that, digital for patent, e-signature with digital both are anyone is required for that. If you want to search, public search. So whatever data you are having, mosquito repellent composition, mosquito catching device, fertilizer composition, herbal composition for the cancer, a process of preparation of beverages, paracetamol composition, integrated circuit having so and so. Or if you're having somebody is from mechanical engineer, fermenter, or a device, or smart cane, whatever you can search, go to the public search, you will come to know. Or you can go to the Google patent, or USO patent, or EPO patent, or WIPO patent. These are the free database available to you to search your prior art, whether your technology new or not. If you're not happy with the prior public domain, which are freely available, go for the other search site as an PATSIR, paid database. You can pay the fees, get your work search. If it is new, you can go for the patent filing. Or if you want to go for the copyright office, please go here, open, create your ID and password, fill that, and keep your copyright work, story, book, whatever you are having in PDF form, upload that and pay the fees online. If you want to file geo irrigation, go here in detail, trademark, go here, and design. So everything is available on the website. Manuals and guidelines are also available. Act and rules are available. So please go with this. Learn more. Then you can go for your technology filing if it is patent, design if it design, trademark, go for the trademark. So depend upon your what kind of IP you have been. So all about the intellectual property rights and their filing. Now, what is the role of patent system? Why it is important? Encouragement for improvement of technology. I got patent for AG Bell, but I got improvement as a mobile, Nokia, Samsung, Apple. Again, improved technology. I was having X-ray machine. Now we got CT scan machine. Improvement, I'm getting that. Providing reward as an exclusive right for disclosure. If you're filing patent, you are getting reward for that. Design, you are getting reward for that. Copyright, you are getting reward for that. So please disclose. Don't keep as an file record. Making profit or earning royalty through putting the image practice. Apple mobile, Apple laptop, Samsung, Nokia, how they're in the market. Sony, Samsung TV, black and white the, डब्बे थे, ऊपर वाले आ गए, LED farm, all are in the market, so they are getting benefit out of that. So transferring into public property after expiry after 20 साल के बाद पेटेंट खत्म, anyone can use, so please make a benefit of that. Pay the renewal fee up to 20 years. If it is unable to pay, then anyone can use your technology, or if it sees, so please pay the renewal fee up to 20 years and keep your patent live. Otherwise, anyone can use your technology. Kya kare? What I can do now? You came to know all about the intellectual property rights. Since morning में वही चल रहा है आपसे. सुबह से लेके invention, innovative ideas, copyright, all is going on. So what to do now? Please share the benefit of patent system or IP system in school, colleges, university, even in the public domain. Because many of people are not knowing what is IPR. I went to Gondia, bambooची छोटे-छोटे design केलेला आहे, पाण्याची bottle केले, टोपली केले, but I was not knowing. But the people are not knowing, so I told them you can go for the design. So it's duty to spread the knowledge of IPR or patent system. Utilize the resource through organized R&D activities. जो भी resource है, R&D करके आप use कर सकते हैं. Capture the global market judicially, means legally. Apple patent लिया, design लिया, trademark, so protect that legally. Earn the profit through protect market. कोई भी इंडिया में जुगाड़ होता है, इसलिए protect करो, then public में आ जाओ. Especially for the teaching faculty, by knowingly, unknowingly, you are going for the conferences or publishing the paper. So within 1 year from the date of conference or published paper, you have to file the patent, not beyond the 1 year. So first file the patent, then go for the publication. With this, I put a full stop to my presentation. Any questions will take for 10 minutes. Thank you.
Thank you, sir. Thank you, sir, for your engaging session. You explain the intellectual property through simple and day-to-day life examples. You also explain the various concepts like patent, innovation, and discovery, meaning of designs, trade secrets to very simple manner, sir. Thank you very much for the as I think there are no questions from the participants. For the vote of thanks of this session, I would like to invite Professor S.R. Powers.
Thank you. I am and it is my privilege to deliver the vote of thanks its session. All dear participants, good afternoon. On behalf of organizing team, I give my heartfelt thanks to everyone who made this one-day national e-seminar on intellectual property right a big success. A very special thanks, a very special thanks to our resource person, Professor Dr. B.N. Suryavanshi sir, Assistant Controller of Patent and Design at Rajiv Gandhi National Institute of Intellectual Property Management, Nagpur. Sir, your session on patent and design filing was excellent. You explained the step for filing patents, inventions, discovery, copyright, design registration, and real life tips so simply that everyone understood clearly. Your experience inspire us to protect our ideas better. Thank you for your time and knowledge and for answering all questions. Professor Dr. Suryavanshi and everyone thank you one again. Your efforts will help us a lot. We look forward to more event. Thank you, sir. Thank you, everyone.
Thank you, sir.
Thank you, dear all. Have a great day ahead.
Yes. Now, dear participants, as we all know, we are having this excellent session since morning. Now, as we have arrived to the conclusion of this event, I would like to invite Dr. Anil Patil sir to deliver the vote of thanks of this conference.
Thank you, sir, for this opportunity. Respected President, honorable dignitaries, esteemed resource persons, faculty members, and dear participants, on behalf of IQAC and the Department of Political Science, Vasantrao Naik Arts Science Commerce College, Shahada, District Nandurbar, Maharashtra, I sincerely express my heartfelt gratitude to everyone for making this one-day National East Conference on intellectual property rights, patent and design filing a grand success. I extend my deep thanks to our Honorable Bhaiya Sahib Sanjayji Yadav, Secretary Satpura Shikshan Prasarak Mandal, and Honorable Tai Sahib Sonamai Shikshan Prasarak Mandal Secretary, and Honorable Dr. Himanshu Bhau Jadhav, Administrative Officer of this campus, for their best wishes and continuous encouragement. We are especially grateful to our esteemed resource persons, Dr. V.V. Gite sir and Dr. B.N. Suryavanshi sir and Dr. Iramala Dayal madam for their highly informative and insightful session. Their experts' guidance has greatly enhanced our understanding of IPR, patents, and design filing. I would also like to thank our respected principal, organizing committee members, coordinators, and technical team for their dedicated efforts behind the scenes. We gratefully acknowledge the collaboration and support of Rajiv Gandhi National Institute of Intellectual Property Management and Kavitri Bainabai Chaudhary, North Maharashtra University, Jalgaon, and all associated institutions. Finally, I thank all the participants for their active involvement and enthusiastic participation, which truly made this e-conference meaningful and impactful. With sincere gratitude to everyone, I conclude my vote of thanks. Thank you all. Thank you very much.
Thank you, sir. Thank you very much. Thank you, all the participants.